We're here for, is this day 15, day 16 of our evidentiary hearing in case number NEPR-AP-2023-0003. It's December 9th, 2025. Welcome to Dr. Tierney, Mark Dady, and Ralph Smith. I need to swear the three of you in. Could you please stand and raise your right hand? Do you affirm that the testimony that you will provide today is true, correct, and based on your own and personal knowledge, and that to the best of your understanding, none of the information you will provide today is misleading or untruthful? All right, thank you. You're sworn. Good luck today. Welcome. We're here for the panel on revenue requirements and related issues to review how I hope to handle this, preferably in 8 hours or less.
Yeah, Mr. Hempley, Margarita Mercado.
One second, I'm mid-sentence. I'll tell you when I'm ready for you to interrupt me. You are, sir? Welcome. Ms. Mercado, what would you like to tell me?
I was going to introduce him, Angel Marzan.
All right, well, he's just done so. So as long as you're, well, we got to make some space here. Hold on, off the record.
Mm-hmm.
Would you please stand? I have to swear you in, sir. Do you affirm that the testimony that you will provide today is true, correct, and based on your own and personal knowledge, and that to the best of your understanding, none of the information you will provide today is misleading or untruthful? All right, welcome, sir. You're sworn. Where'd you come in from? San Juan. Oh, okay. Well, you're here. So here's the sequence. Let's try to keep to it. I'm not going to hold people to precise honoring of the outlines, but let's do our best. Starting with the revenue requirement, the basic equation. Once again, as I've indicated several times, the purpose for that section is not to debate, redebate, argue about amounts of dollars. It's to make sure that all the elements that could go into a revenue requirement are all listed here. But while we're doing that, because they are listed here, we will have questions on margin, on bad debt. And now that it's been made clear, I think that irrigation dollars are all in the subsidy rider, comma. We're not going to discuss that because this case is not about the subsidy rider. It's about base rates. Everybody okay with that? No object. Mr. Gonzalez, welcome, sir. What have you got?
Gonzalez, you need to use the microphone.
Okay, we're short a microphone, Gerardo. If we can get another one in here, well, you better keep yours, sir. Sorry, Mr. Gonzalez, my mistake for not having enough microphones.
It doesn't matter. No need to apologize.
Okay, sir.
I'm just quoting you.
We're going to do load forecasting in the rate design panel, sir. Load forecasting is in the rate design panel next week. Okay?
Okay. So any questions regarding load forecast will be on the rate design.
Precisely. Yes, that's one of the key. In fact, I think we're going to start that way, sir, if I recall. Okay?
Thank you very much.
All right. Thank you. All right.
Mr. Hepling.
Sir.
Corey Brady for the record. I just wanted to clarify your statements about the irrigation subsidy. You're ruling that we will not address them in the hearing, right? Not that they are outside the scope of, for example, post-hearing briefing, right? I believe the issue has already come up in past hearing days, for example.
The last thing I want to do is have an appellate problem because I kept something out of somebody's brief. But what I'm saying is that this case is about base rates, and my information, to which nobody objects, is that cost recovery, revenue recognition, with respect to the irrigation district, is all in the subsidy rider. So at this point, consistent with Act 57, I can't see any provision in the final Energy Bureau order that would address irrigation. If you want to say something about it in your brief, I'm not going to ignore it, but I don't know that it would attach itself to anything in the order. What are your thoughts, sir?
Well, there are other parties that may be closer to this, such as the OIPC, but at least my understanding of the issue from past discussion is that there is a real question of the legality of including this rider and collecting the costs from customers, and that in fact that issue may date all the way back to the 2017 rate order. And so to the extent there is an amount being included in rates to customers that legally should not be, I think it's within the PREB's overall and continuing jurisdiction to address such an issue in the process of adjusting rates.
Well, let's put it this way. If you think, again, you put in your brief what you want to on the subject. If that's what the ruling you want today, put it in. But unless and until somebody convinces me or the commissioners that there are dollars associated with the irrigation district in base rates, I'm not envisioning anything in the final order that would address the matter, because this case just deals with base rates. I agree with you. I was in on the whole 2017 thing, and but that's what I'm telling you. Do you have some understanding that there are costs in the revenue requirement relating to the irrigation district revenue requirement and the base rate revenue requirement?
I don't have an understanding one way or the other related to that, but I will also add that given that the issue was raised in the 2017 rate case and order, that's another factor weighing in favor of it being relevant here in this second rate case.
I'm fine with this. Put it in your brief. Okay?
Thank you.
Of course. Okay. And then just continuing down the agenda so that people know what we're doing today, because I can get mixed up too. If anybody wants to talk about the conversation we have already had about what's going to emerge in that April order with respect to not only fiscal year 26, but also fiscal year 27 and 28, that's the thought piece that I attached to one or more of my orders. We can have that discussion. We do need to talk about, but if Mr. Shen is not here, I'd rather wait until he gets here, the process of reconciling, the methods for reconciling the permanent rates with the provisional rates. If by the end of the day we're not certain he's going to be here, we'll discuss it, but I would rather have the panelists be able to do some back and forth with me on that subject, so we'll hold that off with Mr. Shannon. Next, as I have ruled several times now, I think, on legacy debt, the conversation today is restricted to the pros and cons of having a rider without getting into whether any number would be in the rider, and then how that rider might be designed. That's what that issue is about. I've already reminded us that we're not going to address the fuel and purchase power adjusters because that's outside of this case. And have I left anything out that anybody thinks needs to be addressed today? All right, well, that's pretty good news that we're getting this right. All right, then, and who is going to be examining on this first area? And just so the panelists know, the way I usually do this is I've just articulated the 4 or 5 capital letter areas from the agenda, and what I do is sometimes I have questions first, and then I go to the council to ask their cross-examination on that particular capital letter area, and then we move on to the next area. Today, most of the time, I'll be letting the council do the cross-examination first. So who wants to examine on topic A? Show of hands, please. Mr. Glassman, who else? Somebody from Luma, I thought? Okay, Ms. Chambers, good to have you back. All right. And as you know, ma'am, speak up, please.
I have one for Dr. Tierney.
All right. Well, just know, as I know, I don't want to have 2 lawyers examining the same witness, but as long as you're splitting up the witnesses, that's fine. All right, yes, ma'am. And Ms. Smith, you're in it with us too. Welcome back. All right. Well, why don't we start, since Ms. Chambers, you haven't been here for a while. Why don't we start with you? Nice and loud in there. And there
Sorry,
you go.
the microphone wasn't on. Good morning. My name is Andrea Chambers. I'm with the law firm of DLA Piper, and I'm speaking on behalf of Luma Energy. Good morning, Dr. Tierney. I have a few questions for you on the area margin. So my understanding is that in your answering testimony, you assert that a proposed margin is not necessary at this time because a margin places costs on customers to support PREPA's ability to obtain future financing, even though no new financing is expected until, with debt at least, until at the earliest after the Title III proceedings. Is that a correct statement?
There were a lot of terms in your question.
Okay. So you basically are saying in Exhibit 52 in your answering testimony that you think a margin is not necessary at this time, correct?
Would you define margin as you are using it in the question?
I'm defining margin as it's used in the February 12th order of the Energy Bureau on the rate filing, which required LUMA to put a margin or to calculate a margin based on the typical coverage that a utility, nonprofit utility would be required to have to show investors their creditworthiness.
So in that context, you are or not asking me to include reserve funds in your definition of margin.
Well, let's make short work of this. Your pre-file testimony said don't put a margin into the revenue requirement. Am I right?
I was speaking about the DSCR as a basis for calculating margin, and that was inappropriate.
Okay, well, take it from there, Ms. Chambers.
Okay, so you also testified that a utility that it's unusual and you're not aware of any other utility that funds the entirety of its business with cash. Is that correct?
Yes,
And you would also agree that it's less expensive, and you indeed testify that it's less expensive for ratepayers for a utility to finance its operations with long-term debt rather than cash financing. Is that correct?
I don't think I used the word expensive. I used the word that it is reasonable to spread financing costs over time.
Okay, so it costs less to spread the financing costs over time, correct?
For long-lived assets, yes.
Cost less in terms of current rates. Is that what you mean?
It for ratepayers, it
Right.
costs less than having to pay everything upfront the year that the expense is incurred with cash.
Yeah.
All right. Don't, for both of you, please don't let your voices drop toward the end of the sentence. That's exactly where the important words show up. Next question, please.
So would you agree that PREPA should take the steps necessary to seek financing on the best terms possible for long-term debt?
When it emerges from bankruptcy, yes.
Okay. Would the ratepayers be better off, in your view, if they were able to obtain better financing terms because they had shown credit worthiness?
This is a hypothetical question.
Yes.
Well, in the future, when PREPA emerges from bankruptcy and is standing up to enter commercial markets, at that time, the answer would be yes.
So you would wait until after you'd obtained financing to try to establish creditworthiness?
That's not what it
Objection,
said.
that's not what the witness said.
Well, she gets to ask a question and challenge it. I've said several times. I mean, I appreciate people, alerting the witness, but we've got, as I've said before, I don't consider it out of line. We've all done it to ask a cross-examination question that at least doesn't intentionally mischaracterize to try to fool somebody, but states a proposition that may be at odds with what the witness has said and test whether the witness can make a distinction about it. And so I think the question is a valid question. We've got a capable witness here. Let's hear the question again. And do continue. These objections are very important. I have no problem with them. Go ahead, Ms. Chambers. Let's hear it again.
Would you agree that if PREPA waits till after it obtains, let me try it again, sorry. If PREPA does not have a sufficient margin or cash flow, do you believe that PREPA might not obtain or may incur higher financing costs, and that those higher financing costs would ultimately be borne by ratepayers?
Are we talking about today, or are we talking about when it emerges from bankruptcy?
Well, my understanding is the margin is designed to put the utility in a position to obtain better financing costs. So if you waited till after the financing costs were incurred, and you weren't able to show credit worthiness, is it possible that you would pay higher financing costs?
The premise of your question is hard for me to answer your question. The premise being that before PREPA emerges from bankruptcy, that it needs to indicate to markets that it has a margin, as you're using the term, and that will show in the future a signal to potential creditors that the entity is creditworthy. I think that my position is that when PREPA emerges from bankruptcy, it will be in a position at that period to indicate to the markets that it is creditworthy. We are not at that point yet.
May I for a moment? I'm very interested in this question. Just remind me for a minute, Dr. Tierney, again, taking the definition of margin that you used, your position is no, not in the revenue requirement today. Is that correct or not?
My margin position includes a number of reserve accounts. So if the questions are about some X dollars of additional incremental money above those reserve accounts, that is not necessary today.
Okay, let me work with your answer for a second, please. If you don't mind, Ms. Chambers. We've been using the word reserve accounts in a very technical way. Now I have to make sure that you are using it in the same way. We're using the word reserve accounts in terms of the OMA accounts that where the OMA requires replenishment and certain amounts in those accounts. Is that what you're referring to, or are you referring to something more generic?
I am referring to, I want to make sure that it's the same as you. So let me use my words.
All right.
I understand that LUMA has a storm account.
Something like that. Let's not get too technical, but it's an account that is we call an OMA account. It's required by the contract, okay?
Yes, and that provides money that is usable above and beyond other revenue requirement expenditure.
Right. So as I understand it, your position is as long as the revenue requirement has funds for those accounts that are required by the OMA, your position in your pre-filed testimony is the revenue requirement should not have something above that one would call a margin as you defined it in your pre-filed. Is that correct?
Yes.
Okay. So here's the question that I believe we're trying to aim at, and I've been very interested in, and that is this. I'm just going to state a premise, and you can argue with it, okay? And the premise is that if we had a margin in the revenue requirement today, even as we remain in Title III, that would send a signal to future bondholders that people were ready to, in Puerto Rico, to swallow the medicine and pay extra now to send a signal that there will be that the lending community should have confidence, and that therefore, over the long run, interest rates on the future debt that we'll finally have if we ever get out of Title III would be lower, so that the margin today produces a lower cost result for customers in the long term. Do you understand what I said?
I do.
Okay, and what I want to know is what is your view as to whether there is a long-term benefit of having the margin in the revenue requirement today? I don't know whether that was what Ms. Chambers was aiming at, but that's what I'm interested in. Go ahead, please. And what are your thoughts?
I would not encourage the Bureau to put that in rates today, and here's why. This is a set of revenue requirements based on a cash financing model. And if and when PREPA is ready to enter commercial markets, so many things in the overall budget and revenue requirement calculation have to change. There would be depreciation rates associated with new financings for new assets, rather than having that all in a cash model in the revenue requirements. So if you're thinking about a world in which you're sending a signal to the capital markets and simultaneously trying to assure that customers, ratepayers, pay only just and reasonable rates today, they are apples and oranges. Today, there is, in my view, sufficient numbers of accounts to handle the capital requirements of the operators in PREPA today. That's what customers would be paying for with the revenue requirements without a incremental margin above the other reserve accounts. And there are really important signals that would need to come to capital markets associated with finishing the Title III process. And at that point, in my view, it would be important to have a rate case to look at not just margin, but also the financing arrangements that show up in the revenue requirements of a creditworthy entity that is not doing cash financing for its physical assets.
Okay. I mean, can I just tell you that your testimony surprised me, because I thought, when the Energy Bureau in its February 12th filing requirements order listed margin as an option, I thought the bondholders were going to leap at that and say, what a great idea. This shows real interest in having the ratepayers step up and show us confidence. And you can understand my surprise, yes?
I hear your surprise.
Okay. All right. Well, you have your answer on that topic, Ms. Chambers. To the extent you're happy or not happy with it, please carry on.
I just want to ask about one of the, you mentioned the storm reserve account. Do you know if that account is currently funded?
I don't know one way or the other. And I use that illustratively. I know there are other reserve accounts.
So in a hypothetical situation where none of those accounts that you refer to are funded, would that change your opinion about the need for a margin?
I guess I would want to understand why they are not funded and what you mean by them not being funded. If they're in the revenue requirement at a dollar amount, to me, that is funding it.
Assuming there's a $0 amount associated with that.
So in that
Yeah.
hypothetical, if each and every one of those accounts, the storm account, the 2% reserve account, federally funded reserve account, et cetera, if those were all zero in your hypothetical, there would not be a lot of working capital.
Thank you.
Which would mean that you would think that a margin would be a good idea or a bad idea?
If all of those were zero in that hypothetical, working capital is an important thing for utilities to have.
I'm sorry for the belated objection. I was just waiting for Dr. Tierney to finish, but I object to that last question because the hypothetical is vague as to whether the zero refers to the current amount of account funding or what is proposed in the revenue requirement, which is what we're talking about.
Yeah, I got kind of lost in it myself. Well, carry on, Ms. Chambers.
If it's the current amount is zero in the hypothetical.
Okay, excuse me. Again, I may be the slowest one in the room, but by current, do you mean before let's distinguish two things. An existing revenue requirement that provides for full funding of all of the accounts versus an actual situation where there's less than full money in the accounts. I apologize. The problem I'm having right now, and I think this really goes to what Mr. Brady's concern is there can be situations where there is a level of funding the accounts below the OMA required amount, and the Energy Bureau hasn't gotten around to dealing with that yet in its revenue requirement.
Okay, well, we were talking about the storm account. Let me be
All right,
specific here.
all
The
right.
storm-
Let's call it what it is in the let's call it what it is in the OMA, so the transcript is clear. It's the outage event reserve account. Is that what you're referring to, ma'am? The outage event reserve account, the Luma account with that title.
It's what was referred to as the Gridco Storm Reserve Account.
Mr. Smith, are we okay if we call it the outage event reserve account?
Good morning. Yes, it's defined as the outage account in the OMA, but your description is fine.
It's the outage event reserve account.
That's fine.
Okay. I'll stay out of the way, take a shot at it, but there's a lack of clarity at the moment about the hypothetical.
Okay, well, I was referring to the account that Dr. Tierney said was currently a reserve account. And so I believe she was talking about the storm account. I think that's what her testimony
All
was.
right, well, let's assume that's what it is. And you want to assume that there's,
$0 in the account at the moment.
okay, and what do you want to assume about the revenue requirement? That it
I'm asking if there's $0 in the outage reserve account at the moment. Does that provide any credit worthiness or working capital, for the utility?
I would object again. It's an incomplete hypothetical without addressing what is or is not being requested for that account in the revenue requirement, which is the subject of this case
yeah,
and this panel.
okay. Let me try to sort this out. Ms. Chambers, let me ask you a question. Sometimes I can shortcut things. Sometimes I just make it worse. To tell me in general, what is the proposition that you're seeking to test with this line of questions?
The witness is saying that there is working capital available to serve as, to show credit worthiness. And I'm testing the fact that if the account is not funded, there's no working capital to show lenders credit worthiness.
Well, yes, ma'am. The problem with the question is there could be other, we're sort of, I think, having two wires cross. Whether a company has working capital is a cash question, and there may be cash floating around for all kinds of reasons, despite there being zero in this particular account. I think where you're headed is here, and you tell me if I'm getting us off track. But Dr. Tierney, here's what I'm concerned about. Your comfort with there not being a margin in the revenue requirement, I think, is dependent upon there being elsewhere in the company sufficient cash to cover its working capital needs. Is that correct, Dr. Tierney?
Yes, it is not about whether today, with revenue requirements that are being reviewed by the Bureau for the new rates that would go into effect, whether those are sufficient. The question that was posed to me is about whether you need working capital to be creditworthy. Right now, we're not talking about a creditworthy entity. And the revenue requirements being proposed here are part of a package for a utility that is not creditworthy. It is cash financed. And there are reserve accounts that provide working capital.
All right. Here's how I understand what you're saying. If at any particular point in time, such as right now when we're trying to decide what to put in a revenue requirement, if we assume that each of the accounts is fully funded, your position is there's no need for a margin, as you've defined the margin. That's what I understand you to be saying, right?
Yes, because those revenue reserves
Cover the needs.
accounts cover working capital, which for a utility is typically in the 1 to 2 percentage
All right.
points.
Okay.
And so in my view today, the number of reserve accounts provide working capital.
All right. Thank you. Now let's just change the hypothetical. What Ms. Chambers is asking is
Doctor of Law.
what is that? No, your doctorate is in city planning, right?
Yes, but hers is in.
Is a doctor of law.
Yeah.
Okay. Don't get me mixed up.
Okay, sorry.
Now let's just change the hypothetical.
Okay.
If the funds in the accounts are insufficient, all right, they're insufficient to provide working capital. Let's just say they're at zero. They're all at zero. Okay, Dr. Tierney?
When?
Now,
Before the new rates go into effect?
all right, well, let's do this. Let's assume that with respect, okay, all right. Let's assume that when the new rates are into effect, no, let's assume that in setting the new rates, the Energy Bureau expects that for whatever reason, all the accounts will be at zero. Yeah, I have the same look on my face, but in that situation, what do you think that a margin would be important to have in the revenue requirement? I think that's what she's asking. If you don't like the question, say it's not a good question and you refuse to answer it, but try to answer it, okay?
The reason I have trouble answering that is that means that basically the budget is busted.
Well, really, what the problem with the assumption is that you're asking the revenue, we're assuming that the Energy Bureau is going to set rates in a way that's inconsistent with the legal obligations of the contract, which is not a particularly useful hypothetical. Is that what you're saying?
Because I'm not an expert on the contract, I'm not sure the way you pose the question to me.
All right.
I know the answer.
All right, let's just try to do it this way and see if we can move on. One way or another, it's important to you for the utility to have enough funds for working capital, right?
Yes.
And if it doesn't have enough funds for working capital, the bondholders, both current and future prospective ones, are going to be concerned about the creditworthiness of the company, right? If there's not enough working capital.
Until it emerges from bankruptcy, I think everybody's worried about the creditworthiness of the utility. So for me, there's really an important bright line when we're talking about creditworthiness. Right now, in this rate case, during the bankruptcy status, I think the question is, can the Bureau set just and reasonable rates based on a revenue requirement that is reasonable to cover the cost of operating a utility that is cash financed? And there are reserve accounts that provide working capital. So a margin above and beyond that doesn't seem like a reasonable addition to me.
Okay. I think one last question, and we may have gotten as far as we can with this. Tell me the circumstances under which you think a margin would be appropriate in the revenue requirement. Under what circumstances? When, yeah, not necessarily today, at what point and under what circumstances, if any?
A utility is seeking to issue bonds or go for commercial credit, and the agreements relating to the new debt require some kind of reserve.
Okay.
And usually they specify some approach that's necessary.
Some formula. All right, Ms. Chambers, back to you. I don't know that we're going to get more out of this, Ms. Chambers. I think she's pretty much given us when not to do it and when to do it. And that's what I think we just learned in this last few minutes. Go ahead, Ms. Chambers.
And you testify that you haven't really looked at all the revenue requirements in the filings in this case, right? You're not familiar with what's in the revenue requirement?
I am familiar with it. I have not studied in detail most elements of it.
A little louder,
Yeah.
please, Ms. Chambers.
That's all I have. Thank you.
Okay. Who else wanted to cross-examine? Well, are there other questions for? Right. Sorry, where am I looking? Yeah, just so we're clear, we're going to get all the questions on topic A, but as long as we're on margin, if we don't mind sticking with margin, that would be best. But go ahead, sir.
Good morning, Dr. Terry.
Good morning, Commissioner.
You mentioned Title III, that we shouldn't worry about doing anything before we get out of Title III. Do you believe that, let's say PREPA exit Title III before the period ends, the spray period, which is 2026 to 2028? Do you think once we exit Title III, PREP should do a mini rate case or amend the rate case? Or,
Great question. And I think it would be hard for the Bureau to see that the rates being charged to ratepayers after PREPA emerges from Title III and then goes to commercial markets to try to get new debt. There are so many changes that would need to be part of what constitutes the revenue requirement that I think it would be natural for the Bureau to want to see new rate proposal.
okay. My second question is, should the commission address steps to improve credit worthiness before PREPA exit Title III? And if your answer is yes, what's your recommendation that the steps that PREP could do in this rate case?
I think my answer is not necessarily should you set rates to signal yet that PREPA is credit worthy, because it's not, and the rates don't reflect having a externally financed utility under the revenue requirements that are being proposed. So I believe that the commission should be looking at what does it cost PREPA, LUMA, and HENERA to be operating the system with sufficient revenues to do its job of providing reliable electric service to customers at reasonable rates. And it seems to me that if the Bureau is starting to look at signals about creditworthiness now, I would suggest there's a topic that we'll be talking about later, which is indicate that there will be a rider for legacy debt that will immediately put that into effect, or as soon as practicable, once Title III decisions are made about legacy debt. So I use that illustratively as a signal to markets that the steps are being taken. But I think adding more than that now is mixing apples and oranges in the revenue requirement.
Okay, thank you.
Thank you.
All right, I'd like to get other questions. I'm sorry.
Sorry, Commissioner Ramos.
I do, if I can, try to keep, like to keep the conversation on margin, if we can, sir. Go ahead.
Okay.
Hello, Commissioner.
I'll try. Good morning, Mr. Attorney. Ms. Attorney. You referred to a 1 or 2% amount as a, I guess, sound cash reserve. Would you in our scenario or our situation, would you say that would be 1 to 2% of the entire yearly budget, meaning with fuel and purchase power costs and subsidies and all this, or just 1 or 2% of whatever we determine as the revenue requirement for base rates?
Thank you for asking this question. When I had in mind 1 to 2%, which is the normal range for working capital for other utilities that have a all debt or debt and equity structure, it's 1 to 2% of capital requirements, not revenue requirements, but capital requirements.
Okay.
The capital requirements are all interlaced into the revenue requirements here because it's all cash financed for
Okay.
PREPA and LUMA and Genera.
Okay.
So I'm not sure how to answer your question.
Okay. Let's see how-
Actually, I could add, I don't believe that would include fuel. That's
Okay.
not what many utilities are, that is passed through. They're not,
And we have a writer for that.
yes.
Okay. You also said that in the event that we exit Title III, we should have another rate case because everything's going to change. Would you say that after we make a decision, we have a binding revenue requirement? Would you say that for that same amount that we will have as a revenue requirement, the system as a whole could do more than what just a cash funding? I don't know if I'm getting this right. My point is, how is being, I don't know if I'm getting outside of Mr. Hempling's lines right now, but how does being in bankruptcy affect the ability of the system? I don't want to talk of LUMA or PREPA, the entire system of providing reliable service. Could we do more with the same amount of money if we're out of bankruptcy? That's my question.
Because I have not analyzed the specifics, I'm going to answer generally about what I know about cash financing of long-lived assets versus a commercial financing through debt markets or equity markets or equity markets. And in that case, you would be spreading the cost of investments over their useful life, might be 40 years for transmission, distribution, and or generation. Could be more or less. You would have a depreciation expense. You would have financing costs as part of that. Everything I know about that model is that it provides value to customers relative to a cash financed model. It addresses appropriately intergenerational issues because today customers are paying for projects that are going to be around for decades, and they are not paying for investment that was financed previously through bonds that are not being repaid. So there's a lot of things going on in the proposed rates here, but it makes me think that there would be lower cost or greater value for the customer dollar in a investment creditworthy entity.
Would it be correct to assume that once we exit bankruptcy, we won't have a 100% credit system? It would be part cash, part credit, right? We can't go straight to.
Yes, because there's a whole lot of things that are operated on a 1-year expenditure, which is cash typically, and not capital financing. So it is a mixture.
Okay. Thank you.
I just had a couple follow-ups if I can.
Yeah, can I just ask
One second.
question?
1 second, if I may.
Sure. We got into some new areas. So
I know, and I don't want to go into those new areas right now. I want to stick to margin if I can, or we're going to lose orderliness here. Commissioner?
Yeah, Dr. Terry, how many utilities you have studied that are on a cash-based only model?
0. There are none that I am aware of.
Okay, thank you.
All right, let's see if there, I'm going to do one very quick, violate my own orderliness on the question that Commissioner Ramos just asked. I want to ask Mr. Smith, CFO Smith, because I think you've talked about this before. When we're out of bankruptcy, Mr. Smith, let me give you a couple of examples of what I think Commissioner Ramos was getting at. First of all, vendors might be willing to extend better terms than they are right now because they're more certain that they're going to receive their money paid on time, right?
Yes.
Workers are going to be more likely to come here and work because they are sure that they'll get paid and have a long-term employment agreement that's consistent with their personal needs.
Yes.
Those are examples of what I think are examples of what would be different that would affect the revenue requirement once we are out of cash financing and into a secure future of external financing, right?
That's correct. The one real benefit, additional benefit of having the ability to traditionally finance the utility is what Dr. Tierney was talking about, is a long-lived asset that has 20, 30, 40-year horizon can be paid for over time.
Right. That's
and that lowers the rate.
That's obvious. But there are these other factors too. The way the world is dealing with a company that is now secure, and people are more willing to do business with it, and that could have all sorts of benefits, not just in terms of cash, but in terms of the quality of service.
100%.
Okay. Other questions about margin, please. Ms. Chambers, you will have an opportunity. I'm not going to cut off people's cross. Mr. Glassman, welcome back, sir.
Thank you.
And then Mr. Stoltz, margin questions. Okay. Again, all right. Again, the purpose right now is to help the commissioners decide whether there should be a line item in the revenue requirement that accords to some definition of margin. It's a line item question. Yes, Mr. Glassman.
And just to clarify, Mr. Hempling, we'll have the opportunity to separately do redirect once all cross is said and done.
That's going to be the way I want to do it, if that's okay with you. Otherwise, we're just going to have too many backs and forths. And I think once you have the whole picture of what to deal with, you can organize your cross in a way that'll be your redirect in a way that'll be most efficient. Is that okay?
That's perfect. Very good. Thank you.
All right. Thank you for checking in on me. Did you have questions about margin, Mr. Glassman?
I do.
Okay, well, go ahead. And then Mr. Stoltz.
Thank you. My question, for the record, Isaac Glassman from White and Case on behalf of Golden Tree Asset Management, and speaking on behalf of the bondholder interveners. My questions are for Mr. Smith. Good morning, sir. Nice to see you again.
Good morning.
So sticking with this topic of margin, LUMA's asking for $178 million for a proposed margin for debt service requirement. That's correct?
We are asking for a margin. That's correct.
Okay, $478 million for 2026.
I believe that number is correct. I'd have to defer to my colleague, Mr. Figueroa, but I'll work on the assumption that that's.
Sorry, what did I hear? 178 or 478?
178.
Okay, go ahead.
And it's the same under both the optimal and the constrained scenarios, correct?
That's correct.
And then you're asking for 2027 and 2028, a number that's in the same neighborhood. I think it's a little less in both years, but relatively comparable. Does that sound right?
It does.
And this 178 million, and again, I'm referring to the proposed amount for fiscal year 26, that all represents surplus above the proposed 2026 expenditures, correct?
It represents working capital for the system.
Okay. And this would all be collected from ratepayers?
Yes.
Was any money collected from ratepayers in fiscal year 2025 or margin in the same way that you define it in your testimony?
Yes, there's a 2% adder or variance on top of the budget for
Okay.
fiscal 25.
Separate and apart from the 2% adder, was any additional amount collected for margin?
Hold on, please. So the 2% adder is not what you would consider a margin, correct?
It would be if, for example, there was no variance to the established baseline budget. It would be a margin that would facilitate working capital. To the extent that there were incremental cost for whatever reason, then that working capital would be aligned or used to pay for that incremental cost. So it's a margin, but it's a margin during the year. But once the year is finished, then you can determine how that fund's actually aligned with the budget.
Is that 2% the same as the excess expenditures line item?
Yes.
Okay, so I don't want to get mixed up here. It's the excess expenditures item that you're now using the word margin for, right?
Yes.
Whereas I think, just so we're not totally mixed up, in the February 12th revenue requirements, filing requirements order, the idea behind the margin was something on top of expenditures to signal to bondholders that there was an intent to be credit worthy, which is a different concept, I would assume, than, well, things might go wrong, and so we better have an excess expenditures for contingencies. Aren't those two different things, sir?
They are. And I think about the margin, respectfully, relative to Dr. Tierney. She said that utilities need working capital. I think about the margins of working capital facility. I understand the signaling that it does to the capital markets, but what I'm more concerned about is being able to keep the utility functional with the cash that it collects from its customers, which needs some flexibility in working capital.
Okay, Mr. Glassman, go ahead.
Sure. And again, I appreciate the clarifications from you, Mr. Hempling, as well from you, Mr. Smith. But just to make sure we're all talking about the same thing, do you have your testimony, and I'm talking about your initial testimony, which is Exhibit 2? Do you mind just opening it quickly to page 46?
I'm there.
All right, great. Do you see question 58?
I do. That reads, please discuss Schedule B4 proposed margin for debt service requirement.
Great, thank you. And so when we're talking about margin, for purposes of this conversation, this is what we're referring to, right? What you have in Schedule B4, proposed margin for debt service requirement.
That's correct.
Okay. And the 2% excess reserve, that's a completely separate line item, correct?
In the legacy fiscal 25 budget, yes.
What about, sorry, go ahead.
Also, it's separate in the fiscal year 2026 revenue requirement, correct?
Yes, I believe that's correct.
And it also sits above all of LUMA's expenditures, correct?
Correct.
Okay. And again, just so the record's clear, I believe that you said in fiscal year 2025, there was no money collected for a proposed margin for debt service requirement, but there was money collected for the 2% excess expenditure reserve.
That's correct.
I believe you testified that the 178 million for margin in fiscal year 2026 is necessary so that PREPA has positive cash flow to satisfy future lenders when PREPA emerges from bankruptcy, correct?
That's part of it, in addition to creating working capital for the system.
Okay, so two different rationales. One is for future lenders, another is for working capital, correct?
Yes, but I do not believe those two are necessarily misaligned.
Okay. You have no idea when PREPA will emerge from bankruptcy, correct?
No, sir.
So let's assume that PREPA does not emerge from bankruptcy in 2026. In that case, the 178 million that LUMA proposes collecting for margin wouldn't be necessary to satisfy lenders, correct?
For lenders, no.
Okay, and the same would be true for 2027 and 28, assuming, of course, that PREPA does not emerge from bankruptcy in those years.
As long as PREPA remains in bankruptcy, it has no obligation to lenders. Let me correct. prospective lenders.
Thank you. Do you have Exhibit 79, which is your surrebuttal testimony?
I do.
Do you mind just opening it up to page 15, question 22?
Okay. All right. Let's have everybody do the best they can to get close to the microphone. We've got translators in multiple languages here. Maybe slightly slower in the conversation, not this slow, and see what we can do. I know it's hard. We're both from New Jersey, Mr. Glassman. See what you can do.
I will do my best. Mr. Smith, just let me know when you're there.
I'm there.
Do you see you testify that regardless of whether debt service is being paid, a financially sound utility must demonstrate that its operations can generate sufficient cash to cover operating expenses, maintain system assets, and fund essential capital improvements?
Yes.
If PREPA remains in bankruptcy and it's not able to access the capital markets, to whom must it demonstrate that its operations can generate sufficient cash?
Its customers.
Now, it's LUMA's position that even if margin isn't based on debt service, it still needs to be included in the revenue requirement, correct?
Yes.
And that's because, and I believe you testified to this, LUMA needs liquidity and needs working capital and so on and so forth.
The system does, as in addition to LUMA.
And you testify that if the proposed 178 million in margin is eliminated, LUMA would be left in a break-even position. Is that right?
That's correct. Cash break even.
And it would have no ability to deal with unexpected costs, respond to emergencies, or deal with fluctuations in timing of certain expenditures, correct?
That's correct. Just one clarification. For example, if the outage event account was funded, there would be funds available to deal with specifically outage events. But your question is yes.
Okay. But separate and apart from the proposed margin, and we've talked about this a little bit already, LUMA is also requesting a 2% reserve for excess expenditures, right?
Yes.
And in fiscal year 2026, in the optimal scenario, that's around $32 million, correct?
Yes.
And the 2% reserve for excess expenditures, it really serves the same purpose as the proposed margin.
All right, whoever you are, mute, please, because we got 40 people hanging on every word. All right, next question.
Thank you, sir. The 2% reserve for excess expenditures, it serves the same purpose as the proposed margin, correct? It allows LUMA to address unforeseen expenses without exceeding the approved budget.
It creates system liquidity, yes.
Asking a pretty precise question, which is this thing duplicative? Okay, because I'm mixed up now. You got the 2% adder, which you've got three things, right, Mr. Glassman? You've got the all the reserve accounts, so they're all, let's say they're all fully funded. Now you've got the 2% for excess expenditures, which is for if things go wrong that can't be covered by the reserve accounts. And then you've got this 178 million margin, which in the normal situation is directed to assuring lenders that you'll pay off your loan if things go wrong. To me, it sounds duplicative. I don't know what the bondholder's position is, and I'm just a lowly advisor, but tell me why there's an independent reason for each of these things, Mr. Smith.
So the 2% excess reserve, for example, in LUMA's budget is aligned specifically to the budget. Right. When we think about a 2% system requirement, the biggest swing factor in the system is fuel cost. Right. It's the largest.
Yeah, but fuel costs are covered by a true up every quarter, correct?
That's correct. But to the extent that, let's go back and think about the Ukraine war, when prices spiked. Right. Those invoices have to be paid. Right, regardless of a rider, right, and they have to be paid real time. So to the extent that there's no liquidity or credit facility, that can put a utility broadly, and I'm speaking about the system more broadly, can put the system in a position where it struggles to meet its current obligations until the rider and the true up can be implemented.
So what I just heard you say, first of all, thank you for that answer, is that you want to solve a rider sufficiency problem with base rates. Is that what I just heard you say? I'm not saying you're wrong. I just want to make sure I understood that. It's the first time I realized that.
So I just confirmed with my colleague, Mr. Figueroa. We were thinking about it from working capital perspective for the system. I think and I'll defer to his rate design expertise. I think your point of it being in base rates is correct, but the concept was to solve a broader system liquidity issue.
All right, but I did want to make clear, I have to think about this as a legal matter. That's all. I understand your logic, but I have to think about it as a legal matter, whether it's appropriate to have a base rate solution for a potential fuel cost rider insufficiency. That's what I think you and I are agreeing is going on in part here. Is that correct?
Yes.
All right. I just have to think about the legality of that. Back to you, Mr. Glassman.
Thank you, Mr. Hempling. And just so I'm clear, and I appreciate the answer, Mr. Smith, but the 2% reserve and the proposed margin, they serve the exact same purpose, correct?
The excess reserve serves the purpose that you're describing of working capital for the LUMA budget, right? Because it's aligned specifically with the LUMA budget. The broader system 2% conceptually does the same thing because it provides working capital, but it's a system-wide working capital. So, for example, the 2% excess reserve on LUMA's budget would address issues with LUMA's budget. It would do nothing for a Genera or PREPA if it were to need that similar working capital variability.
So the proposed margin, this 178 million, let's assume for the sake of argument that it's funded. And I apologize if I'm missing something, but would some portion of that money flow to Genera under certain circumstances?
So the revenues that are collected by the system all remain the property of PREPA until they're used for purposes in the system. So, for example, the monthly funding, the operating accounts and various accounts. And so where that 2% would ultimately go or be spent would be at the discretion ultimately of PREPA. Presumably, and I'll put a scenario out there, presumably for LUMA, we have in December and in April, we make large insurance premium payments. Right? We're currently being funded at 1/12 of our annual budget. We don't pay expenses at the rate of 1/12 of our annual budget. So for a month, for example, LUMA were to have to go pay an insurance premium, or Genera had some other expense, or PREPA had some other expense, presumably those funds would be available to cover that.
And when you say those funds, you're talking about the proposed margin?
Yes.
But not the 2% excess expenditure reserve?
Again, to make sure I'm clear with my answer, they both provide working capital for the system. They both provide working capital. When I think about the excess reserve, that is specifically a LUMA 2%. It is not a system 2%. What we are talking about in the additional 2% is a system 2% that would provide liquidity for the entire system, not specifically for LUMA.
Let's say there's an emergency that LUMA needs to respond to. If the 2% reserve for excess expenditures is funded, LUMA could draw on the funds in that account, correct, to respond to the emergency?
That's correct. We would have funds to pay vendors.
And if the $178 million that you're asking for the proposed margin is funded, LUMA could also draw on those funds to respond to an emergency, correct?
Yes, as could the rest of the system.
And you understand that Genera also has a reserve account, correct?
Yes.
And that Genera is also separately requesting a generation maintenance reserve?
I believe so.
Okay. So given the existence of the 2% reserve for excess expenditures, if PREB doesn't approve the 178 million that you're requesting for margin, LUMA wouldn't really be in a break-even position, right? It has the 32 million on top.
If the year materializes as planned, envisioned in the budget, and does not exceed the 2% for whatever reason, you are correct.
What was that reference to the 32 million?
$32 million, and I'm speaking in approximations, but the 32 million is what I believe LUMA is asking for the 2% reserve, the excess expenditure reserve.
All right, thank you.
This is Commissioner Ramos. I'm sorry to interrupt. Mr. Smith, the 2% excess expenditure is strictly for the LUMA budget?
Yes, sir.
The LUMA in the exercise of preparing the entire petition, that do you know if Genera included a similar 2% excess expenditure?
I don't know, Commissioner.
Good morning. This is Maria Sanchez for the record, CFO of Genera. No, we did not.
Okay. Thank you.
Mr. Smith, I suppose this may be implicit in the testimony that you've already provided, but let's say the 2% reserve is funded for fiscal year 26. Luma is still asking for the proposed 178 million for margin on top of that 2% reserve, correct?
For the system, yes.
And Mr. Smith, you were a part of the ERA panel last Friday, right?
Yes, sir.
And you testified that Luma wants the outage reserve funded, correct?
Yes, sir.
And Luma's asking in the revenue requirement for fiscal year 2026 for $120 million for that outage reserve, correct?
The 120 million is to refund or refill the existing outage reserve that has no money in it, as well as recover costs that were previously incurred for outage response.
Understood. It would be just the breakdown, 30 million to fund the reserve and 90 million to cover the previously incurred costs?
That's correct, with an additional recovery in a subsequent year.
So let's assume for the sake of argument that this account, the outage reserve account, is funded. And let's also assume for the sake of argument that the 2% excess expenditure reserve is funded. In that scenario, Luma would have liquidity for responding to emergency outages, correct?
Yes, if the outage event reserve is funded.
And sticking with that scenario, is Luma still requesting an additional 178 million for margin?
For the system, yes.
And during the ERA panel, you also testified, I believe, that Luma favors the implementation of an emergency reserve account, right?
Yes, the concept I described was that the emergency reserve account would establish a mechanism to replenish the outage event accounts for Luma as well as other operators.
Right, it provides added cushion, correct?
It provides resources to respond to unforeseen emergencies, yes.
Okay, so Luma is actually asking for hundreds of millions of dollars of surplus in this rate proceeding on top of the margin that it supposedly needs to ensure that it's not in a break-even position, right?
I would disagree with your characterization of a surplus. What Luma is requesting is working capital to enable, as Dr. Tierney adeptly testified, is currently cash financed and has no access to capital markets. So therefore, any variability in the cost to operate the system, not just Luma, has to be funded from somewhere. And currently, the only source of those funds is ratepayers.
Understood. And I'll stay away from surplus. I believe it's a word that was used, maybe not in your testimony, maybe in someone else's. But either way, Luma is asking for hundreds of millions of dollars on top of the margin that it supposedly needs to ensure it's not in a break-even position, correct?
We are requesting sufficient liquidity to operate Luma as well as the system.
Just briefly, I want to pivot to federal funding, but still within the context of margin, but please.
No, go ahead. Well, I'll just tell you what I'm thinking. I just tell you what I'm thinking about this right now. I'm just, one big person among many. The problem I have now, not with the record, but with the conversation, is that we've got this, what Mr. Glassman called surplus, a large sum of dollars comprised of the following: the 2% adder, the 178, the outage reserve account, and the outage reserve account's counterpart for Genera, and then all the other reserve accounts. Now, I had always understood each of these things to perform a distinct function or a distinct alleged function. I understood the outage event reserve account to perform the function of dealing with outage events that occur at a level of cost exceeding what is already sitting in the other accounts. I had understood the 2% concept to be somewhat overlapping in concept with the outage event reserve account because it's there as a cushion for bad luck. stuff happens. Revenues are lower than you expect. More workers get injured than you wanted. Vendors jacked up their prices. So we have this 2% reserve. It's different. And then this third thing, I had always understood the margin to be, when you go back to the February 12th filing requirements order, I had understood the margin to be the kind of thing that municipal utilities have in their budget among normal expenses, so that when lenders look at the company and say, should we lend money to them, they see that this company has a cushion among the above the normal. So that's the way, at least personally, I as an advisor have understood these various things. And when I understood them that way, they did not seem to me to merge together or to overlap. But now what I'm hearing from you, Mr. Smith, is, well, we just need a lot of working capital around because stuff happens. And I'm not saying you're wrong to want working capital. I'm saying that the whole concept associated with these additional dollars is getting pretty muddy. And that's, I think, the point that is coming through from Mr. Glassman's questions and the concern that A, the bondholders have, and B, the commissioners might have when you depart from the distinction in the original purposes and load it all into a working capital situation, in which case, it seems to me the question for you is, how much do you want for working capital? And I don't think the answer can be just coincidentally the sum of everything in the accounts plus the 2% plus the 178. That just sounds to me too coincidental. And I don't want to take up more time on this right now because there are many other questions, but I'm pretty unsure now what is the rationale for the various positions that LUMA has. Mr. Brady, you're going to add or subtract something? Go ahead.
Yes, for the record, Corey Brady. The bondholders respectfully object to this long colloquy. Mr. Smith has testified on cross. His testimony is what it is, and if his able counsel thinks that it is muddy or otherwise unclear, they will have an opportunity to conduct redirect examination.
All right, your objection is noted. Still, my job as an advisor is to do what I can to make sure the record is as clear as it can be. Next question, please.
Sure. Could the clerk please pull up bondholder exhibit 965? Mr. Smith, I don't know if you have that in front of you or you're able to access it on your laptop. If not, we'll wait for it to show up on the screen.
Yeah, we'll see it up. I'm trying to pull it up here too, but there's so many documents, it does take a little while.
Which exhibit, sir?
965.
Thank you.
And this is an ROI response that you authored, PC of Luma-RR-84.
I'll work off the screen up there. Mine's loading slow on my laptop.
Okay, I just want to direct your attention quickly to answer B at the top of page 2. Do you have that in front of you, sir? Take your time. Just let me know once you're there. And do you see that in your response in item B, you are reiterating your recommendation that margin be included in the revenue requirement? And then if you look at the last sentence of that answer, you note that it aligns with the 2% for excess expenditures provision, which serves a similar purpose, such that LUMA may accommodate unforeseen expenses without exceeding its approved budget.
I see that.
That was your answer, sir?
Yes.
Okay. We can take that down. Briefly, Mr. Smith, are you familiar with the federally funded capital improvements account maintained by LUMA?
Yes.
Do you know roughly how much is in that account?
Today, it's about $213 million.
And that amount that's sitting in that account, that represents obligations for approved scopes of work, correct?
I'm sorry, I didn't understand the last part of your question.
it represents obligations for approved scopes of work, federally approved scopes of work.
Yes, for federally, yes, correct.
So let's say that there's an emergency and LUMA does what it needs to do from a federal funding perspective, and it receives approval to pursue a disaster-related project. It could access the federally funded capital improvements accounts for funding to pursue that project, correct?
If the appropriate conditions are met, yes.
And just one more scenario. Let's say that there's an NFC project that's funded with ratepayer funds, and LUMA subsequently receives reimbursement from FEMA or the DOE or some other source. When it receives that reimbursement, LUMA would then reallocate those funds in its discretion, correct?
No. In that scenario, it would ultimately be a decision that LUMA would have to have a conversation with its regulator about. LUMA's recommendation, I believe, as Mr. Melendez testified a couple of weeks ago, is that there is more than enough work to be done in the system, that we would recommend that those federal funds be reinvested into other NFC projects. However, that determination and the specific projects would be at the discretion of our regulator.
Okay, so anytime a reimbursement comes in, you would then go to PREB for approval before you deploy that funding.
Just to make clear on your statement, it would be when you say reimbursement, I want to be clear that we're talking about a project that was initially funded with non-federally funded capital that then subsequently receives federal funding, not reimbursement for a project that originated as a federally funded project.
Understood. Do you mind going to page 15 of your rebuttal testimony, which is Exhibit 79? Sir, rebuttal, excuse me. Thank you, Mr. Hempling.
I'm there.
And I want to direct your attention to line 335.
I'm there.
And I believe you referenced this earlier, but you note in your testimony that LUMA and Genera and PREPA make a large insurance premium payment in April of each year. You see that?
Yes, I do.
And you list this as one of the reasons why LUMA's request for the $178 million in margin should be funded. Do you see that?
Yes.
Was LUMA able to make the insurance premium payment of April 2025?
Yes.
What funds did it use to make that insurance premium payment?
Operating account funds.
And then just last item I want to run through with you in terms of how LUMA is calculating the margin that it's requesting here. It's based on applying a DSCR of 1.3 to an estimate of PREPA's legacy debt. Is that correct?
Yes.
And the DSCR of 1.3 represents the target ratio for municipal utilities with a BBB credit rating, correct?
Yes.
And the estimate of PREPA's legacy debt obligation is based on a low scenario estimate of legacy debt, correct?
I believe that's correct.
And this low scenario debt service estimate, that wasn't something that LUMA came up with itself, right?
No.
It was provided to LUMA, correct?
Sorry, I was conferring with my colleague, Mr. Figueroa. Those were provided by PREPA.
And LUMA didn't independently vet those
Mr.
numbers. It simply approved.
I apologize for interrupting. It's just that I have an objection. This is beyond the scope authorized in the rate case for the hearing examiner's order. There was supposed to be no discussion on the amount of legacy debt, nor any principle or method for determining such amount.
Okay, first, Ms. Valle, welcome. Good morning. Thank you for the objection. Please be sure to talk loudly into that microphone. If I heard your objection right, it was that you viewed the question as seeking information about the debt, and per my ruling that we're not going to discuss debt as an element of the revenue requirement, that the question was out of line. Was that the gist of your objection, ma'am?
Yes.
Okay, well, this is what I understand is going on here. Mr. Glassman, you tell me. You want to understand the number that is the $178 million number, right?
That's
All
correct,
right,
sir.
I'll follow up with you, and you want to understand how we got to that number, and you've described with Mr. Smith that you got to that number by multiplying 1.3% times the legacy debt, right?
Correct.
All right, now you want to make sure now you want to ask where did that number come from, so you have the ability, if you want to question whether the 178 million is the right amount of dollars to put into the revenue requirement. Is that correct, roughly?
Yes, sir, roughly.
Okay, on that grounds, Ms. Valle, I overrule your objection. He's not going to get into whether the debt is the right number or the wrong number. He just wants to understand the basis for the 178, so he can choose to attack it if he wants to, which is his right. Next question. I don't know where we are. Where were you? Do you have a question pending?
I am not sure. Mr. Smith, I believe you testified that the number isn't one that Luma came up with independently. It's simply a number that it adopted from another source, correct?
That's correct.
Okay. You may have mentioned this earlier, if so, I apologize, but I believe you testified that the amount of margin does not need to be based on debt service, correct?
That's correct.
But Luma hasn't submitted any alternatives in its rate petition, right?
No.
And Luma hasn't withdrawn or revised its request for 178 million for fiscal year 2026 for margin, correct?
It is not.
I have nothing further.
Thank you, Mr. Glassman. Who else is questioning on margin? Okay, and Mr. Stoltz for the unsecured creditors, and is there anybody else? And Mr. Stolberg. Okay.
I also have just a couple questions for Ms. Sanchez Bras.
Okay, well, let's go in that order, if I can remember it. Mr. Stoltz?
Thank you. Eric Stoltz with Paul Hastings on behalf of the...
You're going to have to, excuse me one second. You have to have that louder. Give me 1 second, please. Go ahead, sir.
Thank you. Eric Stoltz on behalf of Paul Hastings for the Official Committee of Unsecured Creditors of PREPA. I'd like to begin with a few questions for Mr. Smith and then move to Dr. Tierney.
All right, don't let your voice drop at the end of the sentence, please. I got bad hearing.
Mr. Smith, do you have any understanding of the administrative expense claim or motion that the bondholders have submitted within PREPA's Title III case?
I do not.
The margin or surplus or any other label that Mr. Glassman asked you about with respect to Luma's request to PREB, did those have any relation whatsoever to the administrative expense motion or claim that the bondholders have submitted within PREPA's Title III case?
Reiterating that I'm not aware of the administrative claim that the bondholders have submitted. The margin is simply intended, excuse me, to provide working capital for the system.
Thank you, Mr. Smith. Dr. Tierney, I'd like to turn to you for just a few questions. If I could refer back earlier this morning to your discussion that you had with Ms. Chambers about margin. I think I heard you correctly, but please tell me if not. Do you agree that margin should be added into rates after PREPA's Title III case concludes?
I don't recall saying exactly that. I said that would be an appropriate time if it were to happen after PREPA emerged from the Title III case. There would need to be a rate case, and the Bureau would need to consider the extent to which there is adequate working capital to signal to capital markets and cover working capital needs. Sorry.
Thank you for that explanation. I also want to make sure that I understand correctly. You are not advocating for any type of rider.
1 second, pardon me, I've got an objection. I think.
I just want to make sure we're not getting into the area of friendly cross. I'd like to make sure that the bondholders this is another set of bondholders have an adverse interest in this witness on the margin.
All right, well, let me hear what the question is. You know, let me hear what the question is, because I'm not detecting a friendly cross yet, but I do agree with you, Ms. Chambers, that I'm not allowing friendly cross. Right now, he's just clarifying what her position was earlier today. So let's hear the next question, and watch out for the guardrail here.
Yes, understood. And just to be clear, I am asking questions on behalf of the committee.
I know this,
questions
it's
entitled
an entirely different party, but just follow my instructions, and I'm not saying you haven't. Next question.
Dr. Tierney, are you advocating for any form of rider within this proceeding in order to pay for or begin collecting money for margins?
It's a yes or a no.
No. And I'm interpreting margins to be defined in the way that I have been talking about it previously in my statements here today.
That's understood and expected. Thank you. Again, earlier this morning, you referenced, I believe, something called cash financing model. Can you please explain in some additional detail what you mean by a cash financing model for as within this rate case?
What I mean is that the utilities costs, whether they are for labor or for operating the trucks or for making an investment to operate and maintain a physical asset, that has to be fully funded by the revenues collected from customers then during that rate year, basically.
The riders that PREB currently has in effect, are those all consistent with a cash financing model? In other words, for example, the fuel cost rider.
I don't believe that the witness testified as to fuel cost riders, but
Well, what's the reason for the question? I mean,
Mr. Emily, I believe I did hear Dr. Tierney say reference the fuel cost rider, but in particular, would like to have Dr. Tierney explain in the context of cash financing model whether that label or categorization applies to the current riders that PREB uses for purposes of potentially drawing a contrast to other recommendations that she is making in this panel.
I'd object to the question as outside the scope. I believe Mr. Hepling said this morning that the riders were not in the scope of this case,
right,
with respect to the irrigation subsidy, so it would apply equally here.
We can exclude the irrigation subsidy if that's.
1 second. The
To be
reason
clear, the rationale would apply equally. That's what I meant.
he's not asking about rider policy. He's trying to understand what she means by a cash model, right? But I don't understand the reason for the analogy. Why don't I don't understand. Are you familiar with the how the rider works, the fuel rider works in this case?
Only in the most general way, and I don't remember referring to it. I'm sure the record's clear, but I don't remember referring to.
All right.
the
Well,
rider.
the problem is she doesn't know enough about the rider to give you a useful answer. Just try to get clarity on what she means by the cash model. But it seems to me pretty obvious. It's in the title. It's cash as opposed to financing. What's the next question?
No, I'll take the witness's response. Thank you.
What's the next question, sir?
No further questions from me at this time.
Okay. Who's next? Is it Mr. Stolberg? Is that who's next? I don't want to get sued for getting out of order here.
Thank you, Mr. Hemming. I'll go if there's nobody else.
Well, there will be. There always is somebody else. Go ahead, Mr. Stolberg.
Between Mrs. Smith and Dady, who wants to testify on margin?
I'll just say Ralph Smith.
Ralph Smith?
Yes.
Okay, I need you to talk right into that microphone, nice and loud, please.
Mr. Smith, or sorry, Mr. Smith, do you agree with Dr. Tierney and the other Mr. Smith on the panel that a utility needs working capital?
Yes.
And you acknowledge that over-collection could be used to fund needed capital expenditures not funded from other sources.
Yes, that would be one use of extra cash collected.
In the microphone.
Yes, that would be one use of extra cash collected from potential use.
And yet you ultimately, in your report, you don't recommend charging for and collecting a margin, right?
That's correct. And we were addressing at the time of the report, the particular margin that Luma had proposed, which was based on a certain multiple, 1.3 times some legacy debt-based numbers. We didn't think that was appropriate.
Would you, having heard the testimony today and having thought about this, would you propose a margin based on some other factor?
We would recommend that if the Energy Bureau is going to consider a margin, that it be based on an operating reserve, not a multiple of legacy debt based amounts. And I do agree with most of which Dr. Turney testified, that there are all these other reserves, and then there's the 2% excess expenditure account. So I think when the Energy Bureau is debating the issue of should a margin be included in the revenue requirement for base rates, it seems like first they need to decide what specific programs are going to be funded out of the constrained or optimal budget. They have to decide for all these reserve accounts, how are those going to be funded? How are the reserve accounts going to be replenished if the funding is drawn down for some reason? And after making all of those other decisions, on the very top of the cake or pyramid or whatever is the issue of how much margin, if any, should be included in base rates.
And you heard what Mr. Smith said about the margin being working capital for the system as opposed to any one of the operators, correct?
I did hear that, yes.
And are you familiar with the fact that all of the other funded, we'll call them reserve accounts, are specific to one operator or the other? That's
That's objection. That mischaracterizes the record on reserve accounts. The ERA is system-wide.
So thank you, Mr. Brady. With Mr. Brady's correction, that with the exception of the ERA, the other accounts are specific to individual operators.
The other accounts other than the ERA and the overall request for margin relate to one of the three entities, PREPA, Luma, or Genera.
And do you see a benefit to the system to having a margin account that would fund an account that could be used as the system needed it?
I see a need for the system to have working capital. Again, I'm not sure that the 178 million on top of all that other stuff, it does seem to be somewhat duplicative with some of the other reserves. But there is an overall need for the entire system to have working capital.
So in terms of the dollar amount, if $178 million in your opinion is not the right dollar amount, do you have a dollar amount that you could recommend to the Bureau?
I don't, because again, like I explained earlier, this comes on top of everything else that the Energy Bureau is going to be deciding that goes into base rates. So once all those other amounts are tabulated in operating margins such as 2% might be reasonable, but I don't have any of that other tabulation yet. And then I think, as I understand it, the Bureau is going to also weigh that against other considerations like affordability, preventing rate shock, et cetera. But something like that might be worth consideration once the deliberations on what is to be included in the base rate revenue requirement get to that point. Again, this is like the item on the very top of the pyramid, the margin that goes on top of everything else that would be approved by the Energy Bureau for inclusion in the base rate revenue requirement.
And assuming that this were a more perfect world and that the system had access to a credit facility. In that scenario, you would generally, the lenders would generally require some sort of margin. Is that right?
Generally, what I've seen from a variety of utilities, including municipal utilities, cooperatives, regional utility authorities, when they have a bond financing or bond indenture, there's typically a minimum requirement in that indenture. Usually they're in terms of not only a coverage ratio, 1.25 times the debt service coverage. Sometimes it's an interest coverage ratio. So yeah, in that kind of context, the lending arrangement and the terms of the indenture would provide information on what the minimum amount of margin would need to be under that type of situation.
This Commissioner Ramos, Mr. Smith, in that scenario, would utilities be required to hold that margin in a separate account?
Not necessarily. Typically, when there's a financing arrangement like that, the margin is included as part of the overall revenue requirement for the utility. But sometimes there are a bunch of restricted accounts where money has to be held for certain pre-identified purposes and can only be spent for those purposes.
So depend on the lender then? A lender might require a utility to have a separate account as a margin, or?
Typically what would be required to go into the separate account that can only be used for a specific purpose would be the debt service requirement itself, right? Because there has to be assurance that the utility has money to pay for its debt service. So the principal and interest on the debt would tend to go into a restricted account and only be available for use for paying the debt service, the principal and interest on the outstanding debt. The margin then, whatever that amount ended up being, then can be used for other purposes by the utility, including addressing fluctuations in expenses. If the revenue comes in differently than what was forecasted, those types of fluctuations, or just for other unforeseen events. Essentially for cash working capital type related items.
Okay, thank you.
I had nothing further, Mr. Hempling. Thank you very much.
Thank you. I think Mr. Brady has some questions on margin, correct?
Yes, just a few follow-ups for Ms. Sanchez-Bras. For the record, Corey Brady, Weil, Gotcho, and Manji is speaking on behalf of the bondholder interveners. Good morning, Ms. Sanchez-Bras.
Good morning, Mr. Brady. Nice to see you back.
Nice to see you as well. Do you recall earlier this morning, Commissioner Ramos asked you about whether Genera had proposed a similar 2% reserve for excess expenditures?
That is correct.
And you said that you had not, right?
We have not.
But just to be clear, as we discussed last Friday, Genera in its optimal budget has proposed a $30 million reserve account funding level, right?
You are totally correct. And as I explained, that is in our OMA.
Right. And Genera has also proposed a generation maintenance reserve, which I understand you think is the wrong word for it, but it is in fact a cushion built in above expenditures.
It's not a cushion like we already expressed. It is called Generation Maintenance Reserve, and it's for paying maintenance on the sites. The reserve name is just a name. It's not a reserve. It's not extra. The only thing that we have in our budget for the optimal is the $30 million that are required to be there per our contract.
Okay, but whatever we call it, you are requesting funding for the GMR, right?
And in the GMR, yes, based on what the name that PrEP decided to put to that amount.
And then, as you mentioned in a clarification that Genera filed, you also have the ability to access service accounts other than the fuel account should you need to do so, right?
Can you be more specific? Please.
Yeah, I'm trying not to bring the document back up because we discussed it on Friday, but there was an ROI response, I believe, that you filed that said effectively under the GOMA, Genera can use money from service accounts to the extent there is money in those accounts to cover expenditures, with the exception of the fuel account.
You're totally correct.
Thank you. And then there is also currently a system-wide emergency reserve account that was created in the provisional rate order, right?
I mean, I know that there is, but I believe that we still have not had access to that.
Okay, but it was created. It does exist,
It
right?
does exist.
Okay.
Yes.
And as discussed on Friday, you think you are proposing to continue having that reserve account exist, right?
That is correct.
Okay, thank you. That's all.
So, Ms. Sanchez-Bras, you've just told me something is helping me understand things. What we are calling the generation maintenance reserve is an operating account.
That is correct.
Simply a bookkeeping recognition that there are going to be certain generation maintenance expenses.
That is correct.
Which, so we can keep track of them per a budget, we identify these funds as being in this account that has the word reserve, but is just another version of an operating account.
That is correct.
All right. That's helpful.
Again, the bondholders respectfully object to this. It's in the nature of redirect examination, which Ms. Sanchez-Bras' very able counsel can do herself should she see a need to do so.
All right. I'll say it again, Mr. Brady, you and I have fundamental different outlook on what the role of the hearing examiner is. You're, of course, free to make your objections, but just so you understand the thinking here, I'm not a party to the case. I'm an advisor to the Bureau whose job it is, among other things, to help complete the record. The record is not merely the sum of what the individual self-interested or public interested parties want in the record. The record is what the Energy Bureau believes is necessary to carry out its statutory obligations. And so it's among my duties to clarify, supplement the record when I can, consistent with fairness. Again, you're welcome to make the objection, but I wanted you to understand that there was a rationale behind what I do here, Mr. Brady. Last comment from you, sir.
Yes, I hear what you're saying. However, I think there is an established process in this hearing whereby parties are able to cross-examine, and then the opposing party is able to conduct redirect examination, and that process should be respected. Also, in terms of the comment about fairness, respectfully, I have noticed that these redirect type questions happen frequently after bondholder cross and not necessarily after other parties crosses. So we would appreciate it if the Utilities Council, they have many able counsel in the room, could simply conduct the redirect examination that they see fit of their witnesses.
Again, my purpose is not redirect, which is rehabilitation, clarification. My purpose is completeness. You've made your objection. I respect it, and we'll continue as we have. And thank you. All right, colleagues, let's talk about where we are and take a break. If I'm correct, there are no more questions of a cross-examination nature on margin, and I'm hearing nothing in response. All right. It's okay if it's short. Again, I don't mind too much passing things around, but at a certain point, we must move. Go ahead, ma'am.
So it was just a very quick question, and it was related to the ability to trigger a new rate case. And I just wanted to ask Dr. Tierney if she is familiar with Puerto Rico legal requirements or Puerto Rico law regarding what is required to trigger a rate case after a rate review.
No.
Thank you.
Colleagues,
I'm sorry, this is Commissioner Ramos. Mr. Smith, the 2% excess expenditures is an OMA requirement, right?
Yes, that concept is included in the contract.
And it's part of LUMA's budget.
Correct.
So it would serve as working capital, right?
That's correct. Or working capital that becomes permanent investment in the system, depending on how the cost of a year evolves.
Okay, so essentially the difference between the 2% excess expenditure amount, and the margin that you're proposing that would serve as a cushion or working capital is that 2% X expenditure is going to reside in Luma's accounts at a monthly basis. It's going to be funded, right?
It would not necessarily be funded. The funding that we're currently receiving is 1/12 of the budget. But yes, the 2% excess that you're describing is aligned with the Luma budget.
But it will be included in that 12th that you're being funded. That 2% is included in there.
Currently, it is not being included in there.
So you're being funded a 12th of the budget minus the 2%?
Give me 1 second to confirm and make sure I answer your question correctly. I can confirm that at the break and answer your question. I just want to make sure I give you the right answer for that.
Okay. I'll leave it there. Yeah.
So,
Thank you.
Sorry, who's speaking?
Just one
Go ahead.
brief question to Mr. Smith. Mr. Smith, as
Sorry,
question.
me or Mr. Smith? Down.
Sorry, Andrew Smith, yourself. Attorney Pedro Vasquez on behalf of the OIPC. As questioned by Mr. Ramos, Commissioner Ramos, he asked you about the 2% in the OMA, and you said that it was a concept in the OMA, right?
Yes.
But it is not a fixed 2%. It is said up to 2%, right?
I'd have to check the legal document for the specific language.
So you don't know. Do you have to? Could you verify that?
Yes, I can review the OMA and answer your question more specifically. I just don't know the precise language as it's written in the document.
Okay, thank you.
Yeah, Mr. Smith, briefly, I'm now having another concern about what you've been saying. In terms of you're describing the 2% piece as working capital. And let me tell you what my problem is right now. The way I learned working capital when I was a young man was that working capital is a necessary part of a balance sheet so that there are funds to cover the lag between two events. The incurrence of a cost, say to a vendor, and the receipt of revenues, say from the customer. That's a different concept, Mr. Smith, from the notion that costs exceed what you budgeted because of a surprise, which is what I thought was the reason for the 2%. So to me, it still sounds like a muddle and a duplication when you assign the concept of working capital to the totality of it all. And I'll just leave it at there, unless you have something to say about it. I think you've got a problem.
Corey Brady, for the record, I would repeat the same objection when this same question was previously asked, and I would also note that it's asked and answered.
All right. It's a running objection, Mr. Brady. I respect it. You don't have to repeat it. We will continue. I will continue to act in the way the commissioners expect me to act, and you are welcome to have a continuing objection, and we'll just have respectful disagreement about this.
Thank you. And I'm just stating the objection for the record to preserve my client's rights as I'm entitled to do as counsel.
Right. I'm saying you don't need to repeat it, and I don't want you to repeat it because it's a running objection. Go ahead, Mr. Smith.
So I actually don't believe we're talking about different things. And let me walk through how I think about this. As the year progresses, you're absolutely right. There are working capital needs as expenses ebb and flow, revenues ebb and flow, and cash ebbs and flows accordingly with that. To the extent that once the year is complete, if the results came in specifically at budget, then the 2% would remain working capital in the system. To the extent that the actual cost materialized at 1% or 2% higher than budget, then that 2% excess expenditures would convert, essentially, for lack of a better word, into direct payment of expenses or direct payment of investment in the system. So I think we're saying sort of the same thing, right? It's a working capital facility, but then depending on how results actually materialize, it may not end the year as a working capital facility. The last point I'd want to make is that when we think about, that's a LUMA specific aligned 2%. When we think about the broader 2%, again, I just want to make clear that's for the system. So to the extent that NEPR-AP fuel cost, whatever it may be, pension cost, whatever, would deviate from plan, that additional margin would be there to address any of those variances in the system.
Okay, thank you. All right, folks, here's what's going to happen next. If my notes are correct, we're going to go to bad debt after the break. And let me take a quick, let me take a quick poll and see who is going to be examining on bad debt. This is a very important topic. We've got a number of numbers in the record, and we're going to have to do our best to find out what the numbers are and who is going to cross on that.
Before we move on, will we be doing redirect on the previous subject now or after all of the subjects?
What I had said at the beginning, I think, is that we would do redirect at the end of the entire capital A.
Okay.
Okay.
I wasn't clear if it was as to witnesses or topics, but at the end of A. Got it.
Yeah, at the end, just like we've been at the end of each capital letter session. Any concern with that? Okay, let me see a show of hands, please. Let me just take a poll. Who is handling Mr. Vasquez Melendez? Give me an estimate, non-binding. Okay, Ms. Smith, what about you, ma'am? Oh, we got some big, maybe there'll be some repetition and some carving out. Mr. Stolberg?
10 minutes.
That's Luma 1. And then Luma 2, Ms. De La Rosa. Beg your pardon? 30?
3-0. I also wanted to clarify that I have some outstanding cross-examination for Mr. Sanabria on third-party pool attachments that we didn't complete on the customer experience panel. And so I just wanted to ask if we should do it now.
Well, not right now. We're going to take a break.
No. At the same time, I do his cross-examination on bad debt, taking the opportunity that he is today present because I don't think he's going to return.
I'll tell you what, when we're done with bad debt, and when I've said, does anybody have any more questions on bad, and you hear a dead silence, you stand up and remind me, okay? Because I'm going to forget. Mr. Gonzalez, you have questions on bad debt, sir?
No, I'm seeking guidance from you.
Sir.
I have some short questions for Andrew Smith and Mr. Figueroa, and some short questions for Mr. Ralph Smith. And those questions, which are short, they are related to all these subjects that we're touching today. And I just wanted your guidance as to when it will be best to do them. It will take no more than 3 minutes.
Okay, so what you're saying is they don't relate specifically to a particular item on the list. That includes A, B, C, D, E, F, and G, but they're generic.
They actually relate to all of them.
Okay.
And it's based on statements from Mr.
Okay, stop right there.
Smith.
Or do you mind if we do it at the very end?
That's why I'm asking guidance.
Okay, well, I'm asking you if you can live with waiting until the very end.
When is the very end?
I don't know yet. We'll see. I hope it'll be sometime today or tomorrow. Okay.
Could we do it maybe just before lunch?
I don't.
5 minutes.
No, because I don't want to interrupt the session. Just check with me after the. Tell you what. Check with me when we finish debt service. So, I mean, whoops. Talk to me when we get done with bad debt. Okay.
Oh, okay. Thank you very much.
And we'll see if we can fit it in then. We'll make sure you get there. All right. Anybody else?
I have a question. This is Mirelis
Yes,
Valle
ma'am.
on behalf of PRAPA. I have a question regarding the agenda under cost item C. It was not discussed today. I understand that there was an instruction on that topic, but I'm wondering if that topic C, the FEMA funded projects, cost of such projects should be covered by federal funds and thus not have to be paid by, not have to be paid for by Puerto Rico ratepayers. Will that be addressed during the federal funds panel?
It's the whole purpose of the federal funds panel. I mean, among other things. Again, the list here was here strictly to make sure that we were all conscious of all the elements that go into a revenue requirement. It really was there stimulated by the portion of the Smith-Dady report, which discusses different definitions of revenue requirement. And so the federal funds panel will be what it's going to be, which is still under construction. I recently received something, I haven't read it yet, from bondholders about responding to my thoughts as to what to do with the federal funds panel, and I've not studied it yet.
Okay, I just wanted to be clear that topic C, it's gonna be addressed during the federal funds panel, although it is under construction, that's a certainty.
It's one of the whole reasons why we're talking about federal funds.
Okay.
Okay, I don't know how you're interpreting it differently from that, but we'll find out, I'm sure, when the time comes. Okay, anything else? All right, you've been very patient this morning. I've learned a lot and I appreciate it. It's at 10:55. I'll see you at 11:10. Thank you. Colleagues, can we take our seats, please? Do I have everybody's attention? These two women that you're seeing up here in the corner of the room, they do translation for the hearing impaired. And it's very important for you to understand what their needs are. They've been working very, very hard for the last 4 weeks. It's extraordinary. But I need you to listen very carefully to what they say to you. Thank you.
Hello, my name is Guinevere Just. I'm one of the sign language interpreters, and I wanted to ask you guys for a few things. The first thing is we really need to identify before you speak, please identify who you are so we're able to transmit who the speaker is of the message. The second thing that we need is if you could please pace yourself while speaking, speak loud, clearly, so we're again able to transmit the message. Please don't speak over each other. Wait till the question is finished to answer. Mr. Hempley says it. Yes, yes, I know we get excited and we want to answer real quick, but when that happens, it overlaps and none of the interpreters are able to, render the message as intended. And when reading, I know, remember our college days, our professors would read super fast and we have no idea what the person's saying. Yeah, so please, when reading, if you could just pace yourself a little bit so that way we can render your messages as accordingly. Thank you so very much for your time.
Thank you very much for your extraordinary contribution. We're turning now to sometimes what's called uncollectibles, sometimes what's called bad debt. What I would like to emphasize is that there are a number of numbers in the pre-filed evidence and in the discovery. The Energy Bureau has two very important needs right now that I hope we're going to accomplish. And they're related. Obviously, what matters the most is to have the right number in the final order. But what has to happen also is that that number in the final order have an evidentiary basis that will be upheld by the courts. And one of my concerns reading what I've read so far is that I'm not always sure what is the evidentiary basis for the number that's being asserted. And so I want to make sure that we accomplish both things. Regardless of what number you're advocating for, there has to be clarity in the record as to the evidentiary basis for it. For example, it's not clear to me that, quote, the FOMB said it, close quote, is an evidentiary basis. It's not clear to me. So I'm concerned about that. Also, it's not clear to me that, quote, the PREB said such and such in the last budget order, close quote, is an evidentiary basis. I'm not saying it is or it isn't, but I'm sharing with you my concerns as a person overseeing the process that's going to end up in the Court of Appeals, that we must have some evidentiary basis for a number. I know that's painfully obvious, but I think in this particular context, it's especially important. Two needs: get a good number, get an evidentiary basis for it. Okay, I've written down the sequence here. ICPO, bondholders, Luma 1, and Luma 2 on bad debt. We all ready? Okay, thank you. Mr. Vasquez Melendez.
Thank you, Mr. Hampling. I'll be addressing Mr. Mazan. Good morning, Mr. Mazan. Pedro Vasquez on behalf of the IPC. Mr. Mazan, you have been retained here by Luma as an expert witness, right?
Yes.
Before this case, have you ever testified in a utility rate proceeding?
No, I have not.
Your background is in taxation and forensic accounting, right?
Yes, and accounting matters.
No utility credit risk modeling, right?
No.
What are your fees in this proceeding?
I charge by the hour, and that is 375.
How much have you billed up to this day, to this date?
20,000.
20,000. Have you ever operated a utility billing or customer information system?
No.
Have you ever managed collection for a mass market retail utility?
No.
Before this case, have you ever testified in a utility rate proceeding?
No.
Mr. Mazan, you were retained to support Luma's proposal of 2.97 bad debt factor, correct?
Yes.
You were not asked to independently determine the correct bad debt factor, correct?
No.
You did not prepare an alternative calculation for that bad debt factor.
I did not.
You do not build any statistical model to estimate expected credit losses.
I did not.
You did not audit Luma's financial statements.
No.
Did you validate the accuracy of the bad debt data used?
No.
You relied in Luma's internal representation without performing an independent testing, correct?
That is just in the evidence files.
You did not you did not request to access PREPA's historical ledgers to corroborate Luma's assertions.
No.
On the provisional rate, the Energy Bureau requested for Luma to provide evidence to support the 2.97 number that they proposed. Are you aware of that?
Yes.
And like I said, you didn't prepare any methodology. Did Luma prepare any methodology?
The one that was submitted on September 3rd, 2025.
Which consisted in just an average of the numbers of past dates.
What is contained in the document, yes.
I would like the clerk to pull up exhibit 242.1. 242.1.
Just see if you can ask the question while we're waiting.
Basically, that the clerk will pull up a document regarding an answer of Luma's to a request for information. It will be OIPCs. I will tell you right away. OIPC of Luma, non-physical operations of OPS 56. Okay, you have it. You have it in front of you. Do you recognize that document I'm showing you?
Yes. Harley.
Where's the laptop that has the yeah, let's pass. Would you mind passing that laptop up there? Thank you, Mr. Sorry, careful. And that has the screen.
I have a hard copy, Mr. Hemplin.
Oh, well, that'll save some time too. I approach the witness.
Since
Have you seen this before, sir?
Mr. Mazan, have you seen that before?
Yes.
Do you consider it for your testimony?
Sir, the question was very short. Did you consider this document before you filed your pre-filed testimony?
Yes, I guess so. Yeah.
If you go to the columns 2024, 2025, it says that the uncollectibles amount recorded for 2024 will be 137,288,000, correct?
Yes.
And for 2025, 398,979,000.
Yes.
And that recorded amount is due to extraordinary write-off made by Luma on those years, correct?
It contains the write-offs.
And basically the variance, the 77 million and the 39 million respectively for 2024, 2025 are due to the extraordinary write-off.
It's a vague question. Could you identify the particular portion? Because before you asked about other amounts in that document, to follow you.
I'm sorry, I didn't hear you.
Yeah, it's based on vagueness, the question, and to clarify the exact portion of the document that you're referencing now.
All right, 1 second. Did you hear the objection?
Yeah.
Can you do something with
Sure.
the question?
Yeah.
All right. Can I remind everybody, please, to talk loudly, slowly, and unexcitedly, unless there's a grounds for excitement. Mr. Vasquez Melendez.
So basically, the variance, do you see the line of variance?
Yes.
Okay. And if you go to column 2024, 2025, it states 77,838,000 and 339,450,000.
Yes.
Okay. So if I subtract those amounts to the amount of the uncollectible recorded, wouldn't that give me exactly the amount of the bad debt that was approved by the PREP and budgeted by Luma?
I'm sorry, can you restate the question?
If you subtract, basically the variance is the difference between what it was budgeted and what was recorded, isn't it?
Yes.
Correct. So basically, if I subtract the full amount of the extraordinary write-offs registered for 2024 and 2025, it will be exactly the amount recorded for Luma. As bad debt will be exactly the amount that was budgeted, correct?
Yes, it's the same number shown as bad debt expense.
So for 2024 and 2025, Luma recorded as uncollectible the exact same amount that was budgeted, correct? So Luma did not state any actual amount of uncollectible, or let me rephrase that. The actual amount of uncollectible stated here by Luma is the budgeted one, correct?
Can answer.
Can you repeat the question?
I just want to, I understand, Ms. Mercado. I just want to make sure I'm hearing the answer, okay?
Basically,
ask the question again, nice and slow.
Basically, the amount that Luma registered and recorded on its book about bad debt for 2024 or 2025 was the amount budgeted, the full amount budgeted.
Yes.
What's your point?
And that will be the 1.5% of the total revenue, correct?
Yes.
So Luma's recorded bad debt accounts for 2024 and 2025 are exactly the 1.5 budgeted, correct?
Yes.
Like I asked you before regarding what Luma proposed regarding the bad debt, and it was an average. Can you tell me that the number proposed by Luma is an average of what years?
The 297 proposed by Luma is not an average.
It's not an average. Are you aware that in the bad debt proposal given by Luma, it said that it is an average of previous years? You don't?
It says that the Excel sheet shown exactly produces an average of 2.86, which is approximate to the 297%. But there is no the 2.97 is not an average per se.
Yeah, but that was my question. We know that the 2.97% is not an average. Is the number proposed by Luma, but Luma said that the average that they did, that you just stated, 2.86%, it is actually the average of previous years. What I want you to tell me is from what years is that average?
Fiscal year 2022 through fiscal year 2024.
Why 2025 wasn't used for this?
That you should ask to Luma officials.
Did you try to use any other numbers presented here to do that percentage to calculate it yourself?
I didn't did an independent calculation.
In your evaluation, you did not perform any segmentation of bad debt between active and inactive accounts?
No.
Are you aware that Luma does not pursue inactive accounts for collections?
Yes.
You did not do any segment of residential versus commercial versus government accounts, correct?
No.
So without segmentation and without proper methodology, you cannot credibly conclude that the 2.97% reflects actual uncollectibles, can you?
This is an estimate. So the answer is no.
But how is done your estimate?
I don't understand your question.
You said that the 2.97 is an estimate, correct?
It is not an accurate number. It is an estimate.
Excuse me. It's just I cannot hear the expert's responses. I would appreciate it if he could speak closer to the mic.
It is an estimate that is not approached by any methodology, right?
What I meant is that this factor, okay, is not 100% accurate. So it's based on estimates.
But is there any methodology that supports the number?
Yes.
What's the methodology?
Well, Luma submitted their proposal on this spreadsheet, which basically what they do is they use the historical data, okay, which is the audited data, I should say, from PREPA, with the Luma data for 2023 and fiscal year 2024. So what they propose is an average based on historical data with their normalized data.
But you testified that they didn't use 2021 and they didn't use 2025, correct?
But they used 2022, 23, and 24.
Any explanation because why they didn't use 2021 or 2025?
Not that I recall.
Are you aware, Mr. Mazan, that Luma has proposed different measures to improve collections and in order to improve revenues? Are you?
Yes.
Would you agree that improvement should result in measurable, sorry to repeat, improvements? Wouldn't you agree that the best practices that Luma is implementing should result in measurable improvements?
Yes.
Same objection.
By improvements, when you answer that question, did you mean improvements in the collection rate?
Yes.
Is that what you meant when you said the word improvements?
Yes.
Next, please.
But you didn't quantify those measurable improvements.
No.
So would you agree that those improvements should reduce the bad factor that is claimed by Luma?
Not necessarily.
If you foresee that collections will improve, wouldn't you foresee that uncollectibles will go down?
If collections do improve, okay, necessarily the bad debt expense, I guess, should be reduced. Yes.
But here it isn't contemplated, right?
I can answer as posed after your question was posed.
Wait a minute. The use of averages for past years, if it does not include recognition of improvements in collections in future years, then the average from the past years will be lower. Sorry. The average in the past years will be higher than would exist if one took into account the improvements in collections, correct?
Yes.
Next question.
Actually, Luma is relying on a 2.97%, which was established as the 2017 rate order, correct?
Yes.
8 years ago, correct?
Yes.
So even though that the administrator changed from PREPA to Luma, and Luma has established some measures to improve in collections, you are saying that the 2.97% from 8 years is the appropriate percentage for this rate case?
Based on the data use, on the historical data use, and these 2 other years, fiscal 23 and 24. There are other factors affecting Luma operations, such as moratorium, when they were not able to make collections. So,
Mr. Marsan, the moratorium ended 2 years ago, 2.5 years ago, actually, correct?
they should be shown on 23, I guess.
Correct? Does it, or I ask you a
I don't
question?
have the exact date, but what I meant is that there are other factors.
I have no more question to this, to Mr. Mansan. I have another to Mr. Smith, but let me verify.
Your cross-examination of this entire panel, please, and then we'll go to the next examiner. It'd be directed to Mr. Ralph Smith.
No, it was Mr. Andrew Smith, but I'm just verifying to my questions if I will go further.
This is Commissioner Ramos. Before you proceed, Mr. Vasquez, just for clarity and my own personal privilege, I guess, could you, Mr. Andrew Smith, could you describe what criteria a accounts receivable needs to, I guess, check to fall into an uncollectible bucket?
I'm sorry to interrupt for 1 second, but now I need to make sure the transcript is very, very clear. If I may, Commissioner, Mr. Smith, I want you to make a distinction for definitional purposes between two things, okay? One is bad debt, which I understand to be prospective prediction of the rate of uncollectibles in a given year versus a write-off, which is a decision about to remove from the books a bad debt from a past year. Is my distinction clear?
Yes, it is.
Okay. Can I ask the commissioner to indicate which one he's referring to? Because the use of the word collectible, uncollectible could end up in both contexts, and that could cause some confusion. Is that correct, Mr. Smith?
Yes.
I have to admit that I'm confused now. Since we're dealing with a yearly or annual revenue requirement, I would presume that we're including in the revenue requirement the amount for which LUMA is not going to be able to, or was not able to recover from customers in a given year. I don't know if that clarifies or what. Okay. Maybe if you could define bad debt for the purpose of this panel, Mr. Smith.
And as Mr. Hempling identified, I'll talk about bad debt and maybe spend just a few seconds on specific uncollectible. Bad debt reflects the expected experience that the utility would anticipate in terms of what it won't collect from customers. So if it bills $100 based on some metric, in this instance, past performance, how much of that $100 will it actually collect from customers, because some customers won't pay for whatever reason. Right? That's a rolling concept that changes over time based on how the customer payment experience is occurring. That may change because of proactive measures from the utility, right? Increased collections activity, disconnection activity, and that sort of thing. It could also change because of external factors, COVID, storms, collapse of the economy, whatever it may be. When we think about an uncollectible account, I think about that more account specific. For example, a customer who has not paid and we visit their facility or their home and they've left island. Right, it's going to be harder to collect from that customer than it would be from somebody who's currently living in that home. A commercial account, for example, that has filed for bankruptcy and closed their business. Right, that's an uncollectible type account.
Okay, so then I guess my question will be more clear. When does an uncollectible become a bad debt? Is that better, Mr. Hempling?
I probably would have said it the opposite. I would have said, when does a bad debt become permanently uncollectible and therefore written off?
That's right. And so back to my illustrative example of $100 that you bill a customer, you would recognize a bad debt of, let's say, $2 against that $100. Okay? What that does is that in your financial records reflects that there's an expectation that there will in the future be some write-off for an account that's uncollectible. Right. What then happens is you proceed through time, let's say 6 months later, 12 months later, 18 months later, after that bad debt was set up, and you determine that in fact, customer one is not a collectible account. Okay, you would then write that account off. However, by recognizing bad debt in a prior period, you've already reflected the fact that you are going to have customers that you will not collect money from. So it's aligning the recognition of the risk that you're not going to get 100% of what you bill customers with the period in which that occurs, while the actual write-off process may happen 12, 18, 24 months later. After you've made all efforts internally to collect from the customer, you've handed the account over to a collection agency perhaps, and they take 3 to 6 months to try to get whatever recovery they can out of that customer. Once that works through that process, then you would deem that actual specific account to be uncollectible.
A write-off is a maneuver relating to the balance sheet.
Correct.
Whereas the bad debt that we're talking about relates to income, which becomes the basis for a revenue requirement.
That's correct.
Can you hear us now, interpreter? No? Yes, can you hear us? Okay, thumbs up. Thank you.
All right, let's get the exhibit up, please. Getting there. He's just coming back into the office. Okay, the exhibit is up.
Is the stream back up?
Yes.
Okay, so I can proceed.
Yes. Oh, yeah, that's what I said. Yeah.
Okay, so Mr. Marzan, thank you for bearing with me through those technical difficulties. I was asking you about years 2024 and 2025 in this exhibit, and I believe that you said you did not consider the 2025 1.5% number. Is that right?
Well, when you say I did not consider, I should clarify that it is Luma did not consider for purposes of supporting the 2.97. What they did was an average methodology using fiscal year 2022 through 2024, and they came up with the average of 2.86.
So in other words, the 2.86% average excludes the 2025 number, correct?
Yes.
Which is 1.5%, as we discussed, when you exclude the extraordinary write-offs, right? That's what you said.
No,
just a moment ago.
That is not what I meant.
So you're changing your testimony?
Nope.
Okay, so I'll ask the question again that I asked a few moments ago, which is when you exclude the extraordinary write-offs from the 2025 number in this chart, the level is 1.5%, right?
That's the approved number, 1.5, regardless of the extraordinary write-offs.
Okay, and 1.5 is less than 2.97, right?
Yes.
So you didn't include that in the 2.86% average. In calculating that number, you did not include the 1.5%, right? It's a simple question.
I think you're mixing up the percentage. So 1.5 is the percentage approved, right? The 2.86 it's a calculation based on the past year's average. Okay, then they're using fiscal year 2024, which do include certain write-off. Okay.
So what I heard you to say in response to Brother Counsel is that in calculating the 2.86% average, you used in this chart 2022, 2023, and 2024. Are you with me so far?
Luma did, yes.
Are you a Luma witness?
No. The spreadsheet was prepared by Luma. That's what I meant.
Are you testifying on behalf of Luma today?
I am an expert hired by Luma Council.
Okay. So by extension, if you included those years from the chart, that means you didn't include the other years in the chart, right? It's just a simple yes or no.
The chart, the average of 2.86,
yes,
does not include year 2025.
And it also
doesn't, year, I should say.
And it also doesn't include year 2021, right?
Right.
Which is 2%.
Yes.
Which is lower than 2.97% as Luma is proposing, right?
Yes.
And as you said in response to questioning by Brother Counsel, as you sit here today, you have no rationale for excluding those numbers, both of which happen to be lower than the number that is proposed by Luma in this case.
There's no rationale included in the spreadsheet. No.
Thank you.
The bondholders complete their cross-examination on this topic. Ms. Smith.
Hello, good morning. For the record, this is Kara Smith, Weil, Gottschall, and Manges on behalf of the bondholder interveners. I have some questions for Mr. Figueroa on the bad debt factor.
Okay, we need you once again to talk as loudly as you can and slowly, please.
I'll do my best. Mr. Figueroa, part of LUMA's mission in taking over from PREPA in 2021 was to, taking over operation of the T&D system, was to improve billing and collections, right?
Correct.
And when LUMA took over, it inherited numerous uncollectible balances from PREPA, right?
Correct.
And there are also structural deficiencies in PREPA's information about uncollectible balances, right?
Correct.
And since that time, LUMA has made improvements with respect to its collection process and its management of receivables, right?
Yes.
LUMA formed a revenue protection team, right?
Yes.
And LUMA is also enhancing its customer care and billing system to automate the identification of accounts requiring collection actions, right?
Yes.
LUMA has improved oversight, right?
Improve, sorry, can you restate that?
Improved oversight,
Oversight?
Yeah.
Oversight over what?
the collections process.
Yes.
And LUMA has implemented more disciplined credit practices.
Yes.
And as a result of these steps LUMA has taken, would you say that LUMA's management of receivables is trending in the right direction?
I would say we are addressing legacy issues that were found.
Would you say that LUMA's management of receivables is trending in the right direction?
Again, I would say there's many challenges. We're dealing with them. I don't know. I wouldn't necessarily characterize it the way you're saying, but we are progressing. Yes.
Well, are you progressing by lowering the bad debt amount or not?
No, we're progressing on addressing the legacy issues that underlie the billing and financial systems.
And would you anticipate that these steps you're taking will result in a future improvement in the management of its receivables?
Over time, yes.
And you would expect it to continue trending in the right direction going forward, right? Assuming you're continuing these efforts.
Objection, that's contrary to his testimony because it assumes that it's trending in the right direction.
Again, she's allowed to ask a question that challenges the witness as long as it's not intentional mischaracterization. What's the concern, sir?
It's fine. Answer the
question. All right, well, 1 second. Again, I want to ask you, Ms. Smith, your voice is dropping off, and I'm as close as anybody else to you, so do your best, and thank you. And let's have the question again, please, Ms. Smith.
All right. You'd expect it to continue progressing in the right direction going forward?
All else being equal, yes.
Great. And as Brother Counsel just discussed with Mr. Marsden, LUMA is proposing a 2.97 bad debt factor, right?
That's right.
The Energy Bureau approved a bad debt factor of 1.5% in its annual budget since fiscal year 2023, right?
That's correct.
And LUMA itself has applied a 1.5% bad debt factor in its past budget requests, right?
Yes.
And this new bad debt factor of 2.97% is nearly double that, right?
Yes.
And the 2.97% bad debt factor that was from the January 2017 rate order was actually based on data from fiscal year 2016, right?
I don't recall specifically 2016, but it was based on the information that was provided in connection with the 2017 rate order.
I'd like to pull up OIPC Exhibit 245. Mr. Figueroa, I believe this is a response to an ROI that you responded to. At the bottom of page 1, it says the 2.97% was based on the ratio of uncollectibles to utility operating revenue that PREPA said that it experienced in fiscal year 2016.
Right. That's part of the rate case. Yes. 2017 rate case.
Does that refresh your recollection that the 2.97% bad debt factor from the January 2017 rate order was based on data from fiscal year 2016?
Yes.
And fiscal year 2016 was roughly a decade ago, right?
Yes.
That was long before Luma took over operation of billings and collections, right?
Yes.
Before submitting its proposal on July 3rd, Luma did no quantitative analysis to determine if the 2.97 bad debt factor is accurate, right?
Also, yes.
This was not a data-driven proposal, right?
It's I don't think I can answer as you're characterized as you're making the question. It is based on it is the number that was used based on based as the outcome for the last time this issue was assessed in 2016.
I'd like to pull up bondholders exhibit 1.08. I mean, sorry, this is Luma exhibit 1.08. My apologies. And this is also on the PDF of Mr. Figueroa's direct testimony. This is PDF page 121.
Okay.
It says persistent limitations in PREPA's billing and financial system data prevented and prevent Luma from submitting a data-driven proposal for bad debt in this rate review. Correct?
Yes.
Does that refresh your recollection to my prior question? Okay. And Luma did no analysis of aged accounts receivable to develop the projected fiscal year 2026 amount for bad debt, right?
Correct.
The 2.97% was not an accurate, credible, data-driven factor, right?
I'm not sure. I mean, it's not a number that we develop, and we've explained at length the issues that surround the ability to pinpoint with precision to what the actual percentage would be. But
appreciate that, but that was a yes or no question.
Can you restate it?
The 2.97% was not an accurate, credible, data-driven factor, right?
Accurate.
I'd like to pull up OIPC Exhibit 245. And you stated, this is PDF page 1.
I'm sorry, which exhibit?
OIPC Exhibit 245.
Okay, thank you. Just give me a second. Okay, I'm there. Are you there, Mr. Figueroa?
Yes.
Okay.
And at the bottom of the first page, Luma will, about halfway through the paragraph, I believe you're the responder to this RI, Luma will eventually be able to produce an accurate, credible bad debt factor. But in the meantime, for the purpose of the present rate review, Luma chose to rely on blah, 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 blah.
What's the question?
You said that, correct? That's your RI response?
I object to the blah, blah, blah.
All right.
I
but it's-
apologize. Okay, we can, I can
Just
read.
a little less.
All right.
A little levity, Mr. Hempler.
Unfortunately, I'm not laughing because we've now spent an hour saying what I said at the beginning of this section, which is that we need an evidentiary basis, and all we're doing is repeating the facts that there is not an evidentiary basis. I hope at some point future cross-examiners will help us find an evidentiary basis. Otherwise, we all have a problem. Thank you, Ms. Smith. Continue.
All right, I'll move on. And Luma does expect, as I think this RI exhibit we just looked at indicates, Luma does expect to have a more precise bad debt factor at some point in the future, yes?
Yes.
And Luma has to go through a cleanup and remediation process, right?
Yes.
And as I believe discussed earlier with Mr. Marzan, Luma did do a cleanup of backlog debt in 2024 and 2025, right?
It did.
Do you have
some cleanup? It did not do full cleanup, but it is part of the write-offs and effort in that, but it's not complete.
It did a significant cleanup, would you say?
It did I'm not, I don't think I can characterize it as significant or insignificant. It did a cleanup.
Right. Do you have an estimate for when Luma is going to be able to put forth an accurate and data-driven bad debt factor?
No.
Is Luma going to go to PREB and seek to revise its bad debt factor once it has this more precise number?
Calls for speculation.
You're the Director of Regulatory Affairs, correct?
And the Chief Regulatory Officer, yes.
All right. Well, when you get around to coming up with a bad debt factor that you can defend on a professional basis, are you going to come in here and report it to the PREB?
Yes.
Next question, please.
We spoke earlier about steps Luma has taken to improve its management of receivables and its collection process. All things equal, when a company improves its collection process, you would expect its bad debt would go down, right?
Yes.
Luma did not account for any such trend whereby its bad debt gets lower due to improved collections in its revenue requirement, right?
Well, you have to compare it against a starting point, and that's part of the effort that's being established. We don't have the right starting point to say what it was at a certain point, and then how it compares to where you are today.
But the 2.9, you have no mechanism in your rate petition whereby the 2.97% number will be declining over the rate period, right?
At this moment in time, we don't have the confidence to state that, no.
So that's no, right?
At this point in time, we don't have the confidence to state it.
Bad debt reflects sales that cannot be collected, right?
I believe my colleague, Mr. Smith, explained the definition of bad debt.
Let's get the question again. Okay. He's not going to give up his whole case, Ms. Smith. Ask the question again, please.
Bad debt reflects sales that cannot be collected, right?
My understanding is bad debt reflects an allocation of an amount of sales that are not expected to be collected in a given period of time.
And bad debt is not intended to reflect accounts that could still be collected with proper effort, right?
As my colleague Smith explained, as at a system-wide level or a utility-wide level, yes.
And bad debt is not intended to reflect poor customer data, right?
I'm sorry, core?
Poor customer data.
I don't understand the question.
The bad debt expense that's used in a revenue requirement should not reflect poor data, correct?
I'm going to object to that question because I don't understand it either. Even when you asked it, sir.
I'll move on. Does bad debt include accounts that Luma sends to collections agencies?
I need to hear that question louder, please. Please don't drop off at the end of the sentence.
My apologies. Does bad debt include accounts that Luma sends to collections agencies?
My understanding is we do not, to the best of my recollection, our customer experience person would be the best one to validate this, but we do not send any information to collection agencies.
Oh, hold on, and I'm concerned that the transcript is about to become unclear again for the reason that I discussed before, that what we send to a collection agency, as I understand it, Mr. Smith, relates to a non-payment that occurred in the past. Is that correct, Mr. Smith?
That's correct. A customer who's not paid would be referred to a collection agency.
Right, but it's an event that occurred in the past that we're dealing with.
Yes, sir.
Whereas when we talk about bad debt for purpose of a revenue requirement, we're talking about bad debt with respect to the rate year that is likely to be, at least in part, a prospective period, correct?
That's correct.
Next, please.
Does LUMA's future bad debt collection, what's included in LUMA's bad debt factor in a prospective sense, will that include accounts that LUMA sends to collections agencies?
No, again, to clarify, bad debt is a forward-looking concept that attempts to estimate what will not be collectible. There are accounts that would be transferred to a collection agency at some point in time that could be and likely will be a subset of the bad debt, but may not be the entirety of the bad debt.
All right. LUMA has been struggling with discrepancies in its reporting of balances owing on a customer account, right?
There are challenges associated to that. Yes, I wouldn't say we're struggling with.
In one of its ROI responses submitted on July 3rd, 2025, LUMA reported that the balance owed by residential customers as of May 31st, 2025 was $728.8 million, right?
If it's on the response, I don't recall the document itself.
Can I represent that?
Mm-hmm.
And then on July 22nd, 2025, in your response to a later ROI, and this is, don't think we need to pull it up, but this is OIPC Exhibit 345, you explained that the data provided in the July 3rd ROI response contained an error, and the balance owed by residential customers was actually about $364.7 million. Do you recall that?
Oh, yeah, I think.
Yes.
Right, and this was a response by Mr. Figueroa, so he also recalls that.
Yes, I'll say yes.
Right, and that's nearly 400 million lower, right? That's about half the number previously reported.
Yes.
Do you know what the most current balance owed by residential customers to LUMA is?
Not at the top of my head, no.
Okay. Thank you. No further questions.
Okay, let me get some estimates again. I got L1 is 10 minutes. What was L2? In terms of bad debt inquiry, Ms. De La Rosa, what was your estimate? 30 minutes?
30 minutes or less, she says.
Okay. I want people to join me in the problem we have, please. I'm becoming less and less interested in cross-examination showing the obvious that we don't have a good basis for a number right now. We don't need to repeat that. Now, what's the purpose of your cross, Mr. Stolberg?
It's to ask Mr. Smith and Dady about their 1.5% recommendation.
Well, we haven't spent a lot of time on that problem, so you'll get to ask about that. And Ms. De La Rosa, what's your purpose, ma'am? I'm not meaning to restrict. I just want to gather some information.
Just some examination on Mr. Sanaria's proposal.
Okay.
Which is the 1.5 as well.
Okay, so we're going to have to address the 1.5. And I wanted to tell you, colleagues, when we're done with that, we're going to have accomplished two things, which I think I knew about already, that there are problems with the 2.97, alleged problems, and that there are alleged problems with the 1.5%, and that what I don't have yet is some solutions. And I hope people are thinking about reaching a settlement on this number, because I'm not sure how else we're going to handle it yet. But Mr. Stolberg, please continue.
Thank you, sir. Mr. Smith, is it Dady? Am I pronouncing that correctly? Yeah.
Yes, that's correct.
Which of you would like to respond to questions about bad debt? Not everybody volunteer at once. Okay, thank you, Mr. Dady. How is, just generally speaking, in a very as quickly as you can, so as because I don't think anyone's set the table here. How is bad debt generally calculated in a utility?
Push the button every time, or is it just
If you
by dividing the bad debt expense by operating revenue?
and you use that using historical numbers?
Generally, yeah.
And do the utilities ever rely on industry averages?
I guess that's a possibility. I think that it would be more based on their own numbers, though.
And is that because each individual utility has different levels of performance based on the customer base and the particular experience of that region?
Sure. I mean, because different utilities have different levels of customer base and revenues and so forth.
How would you deal with, this is a really open-ended question, but how would you propose dealing with the data, the historical data problems that LUMA faces due to PREPA's historical data issues here?
Given the
Hold on, I'm finding that question vague. When you say how should he deal with it, you mean how should he deal with it in the context of creating a bad debt number for revenue crime purposes?
Correct, for exactly what we're trying to do here, which is pick a number that is as data-driven as possible. How do you deal with the data issues? Mr. Smith, would you like to answer?
Yeah, I'll deal with that question. I think the data we're looking at, that everybody's been looking at on bad debts, is all basically the same data. And that's reproduced in our report on PC Exhibit 62.07, page 34 of 37. This has the audited data for fiscal year 21 and 22, and unaudited data fiscal years 23, 24, and 25. This has operating revenue, it has bad debt expense, approved by the Energy Bureau, it has bad debt expense budgeted by LUMA, and you can make various calculations based on that data. And I thought we heard earlier what was a very important clarification, that numbers on the second line for fiscal years 20
and I apologize, sir.
and 2025.
Which page are we on of your report?
PC Exhibit 62.07, page 34 of 37.
It's an appendix. Is that what we're looking at?
Yes, it's taken from a response from LUMA to a requirement of information.
All right, hold. Give me 10 seconds to find it.
Is it filed as an exhibit? Do you know that we could?
It's an exhibit to his report.
Yeah, it was attached to our report as an exhibit.
Okay.
PC Exhibit 62.07, page 34 of 37.
34. Okay.
And it's my understanding that the same set of numbers is also appearing in a number of other places. But I think this is the data set that we're dealing with for addressing the uncollectibles percentage.
I see. And this looks a lot like what we saw earlier on the screen. Is that right? The OIPC?
I believe it's the same data set of numbers for the same fiscal years, yes.
So if this is all the data that we're working with, and this is all the data that we have confidence in, how did you arrive at your recommendation to the PREB of a 1.5% bad debt number?
What we're trying to do here is determine a reasonable and prudent bad debt percentage that would apply to the revenue requirement that the Energy Bureau is going to approve for fiscal year 2026. So looking at all this information here, I mean, it varies somewhat from year to year. Some years may not be representative because they included impacts of COVID. And the 2024 and 2025 fiscal years in particular include amounts of extraordinary write-offs, which we just heard testimony about that earlier. So when you remove the extraordinary write-off amounts, this data is converging around 1.5% for ordinary uncollectibles. Again, you don't want to build in a bunch of extraordinary write-offs that occurred from LUMA's trying to clean up the accounts receivable information that they received when they started taking over from PREPA. And they're still not in the process of having that totally cleaned up. So we want to determine reasonable and prudent ordinary uncollectibles. We don't want to have an element of extraordinary write-offs in this that pertains to amounts that were recorded as account receivable several years ago. And I think once you factor that in, the numbers in the more recent years are converging around the 1.5. Now, is that a totally data-driven number? It seems to be driven by this data. Is this data ideal? No, it's not. In a normal rate case, what we would do is go through several years of audited financial information or information from the utilities for Form 1, which is standardized form of reporting for electric utilities using the uniform system of accounts. LUMA doesn't have that. So we can't do that, but basically we would divide account 904 uncollectibles expense by electric utility operating revenue and come up with percentages. And it's fairly common to use look at a number of years, not just the test year, and then to determine what appears to be a normal, reasonable, prudent level for that uncollectibles percentage. That's how it would normally be done. Unfortunately, in this rate case, we don't have that normal utility type information. What we have is basically the information shown on PC Exhibit 62.07, page 34 of 37, and which I think is similar to what was shown on the screen earlier. So that's the information we're using. And that's the information that I believe the Energy Bureau will need to use to determine what uncollectibles percentage should be used in determining the base rate revenue requirement.
In excluding entirely the what we've called here the extraordinary write-offs, did you take into account the fact that essentially the utility was not allowed to collect any customers, was not allowed to pursue disconnection of customers following Hurricane Maria and then during the COVID period?
Yeah, Hurricane Maria was in 2017.
Correct.
But some of that may have remained in the accounts receivable, and that should have really been addressed on an annual basis, but it wasn't. The COVID period might be in the 2021 numbers, and that uncollectibles number, as I calculated, is 1.95%, using the first two lines. So there may have been some impact from collection policies that were in place at that point in time.
Were you aware that the governor of Puerto Rico's executive order on past due utility bills only expired in 2023? What I'm trying to get at, and I'll just try to cut through this with a little bit more conversation, Mr. Hempling style, is I'm trying to see if it's really correct to exclude all the extraordinary write-offs from computing bad debt, given the extraordinary nature of the years that preceded this data set. Do you kind of understand that? Am I explaining it well enough?
There's an issue, I think, of whether to exclude extraordinary write-offs, such as the ones that were recorded in fiscal year 2024 and fiscal year 2025, or if those are going to be considered, should you consider a portion of those as being, is it normal to have extraordinary write-offs, I think is what you're asking.
A little bit. What I'm trying to say is, this is a prospective look, correct? We're trying to figure out what the uncollectibles will be over the rate period. Is that what we're doing here, as you understand it?
We're trying to determine a reasonable and prudent level of uncollectibles for fiscal year 2026, basically.
Yeah, that estimates the actual amount, the 3 cents of the $100 or the dollar that the system won't collect from customers. Is that right?
3 cents, did you say?
Pick 3 cents, 4 cents, 5 cents, whatever the uncollectible is.
Yeah, the uncollectibles, it looks like it's going to be the 1.5%, appears to be reasonable based on the data.
I'm just talking
The
conceptually.
very high side of that would be the 2.97 that Luma originally proposed.
Right, and I just want to get an agreement conceptually what we're trying to do here so that what I say next makes sense. So we're trying to figure out prospectively what the utility is unlikely of what it bills in revenue to collect from customers. Is that right?
Right, for fiscal year 2026.
Right, so in the future.
And
by
not, I mean, the accounts receivable have not been totally remediated yet. So there's going to be an element of remediation that's going to occur in fiscal year 2026, but that relates to prior periods. So it seems to me that should not be included in the uncollectible rate for the revenue requirement that the Energy Bureau is determining in this rate case.
Let me challenge you a little bit on that, okay? Because assume for me that from 2017 to 2023, that Luma or its predecessor PREPA was unable to disconnect customers for failure to pay, okay? And so if we're trying to use data from the past to figure out what's going to happen in the future, it wouldn't be appropriate here, would it, to write off or to exclude all of these quote unquote extraordinary write-offs? Because some of those extraordinary write-offs actually contained bad debt that you would have accrued in the past, but didn't, due to these extraordinary circumstances.
If the Luma has the ability to shut off customers and pursue normal collection activities now in fiscal year 2026, and didn't have that in several prior years going back to 2017, you shouldn't drag forward that past history, which may have produced some of these extraordinary write-offs that have historically been recognized by Luma. You shouldn't rely on that past history, which is no longer the current policy in place, as I understand it, right? Those restrictions ended in fiscal year 2023, which I think you said and is part of your assumption. So that shouldn't be considered then in determining what a reasonable uncollectibles rate is for fiscal year 2026 for purposes of the utilities revenue. You need to look at policies that are currently in place during this current rate year, basically. And those former policies that may have driven up uncollectibles because you couldn't pursue normal activities that would be associated with trying to collect the revenue that was billed. If those no longer apply, then the Energy Bureau, in my estimation, should no longer consider those as a factor that may have increased historical uncollectibles.
Would your answer change? My colleague just handed me a note that said the restrictions ended in natural year 23, but Q3 of fiscal year 24. Does that change your answer at all with respect to the data that you relied on for the 1.5%?
If those restrictions all ended before July 1st, 2025, which is the start of fiscal year 2026, it seems like that historical data becomes less and less reliable for determining a reasonable uncollectibles rate.
And okay, so assume that it is unreliable. How, as an expert, do you approach? Because it seems like to me, when I read your report, I'll just say this, that the 1.5 was a default rate. Would you agree with that?
Based on the imperfect information that we have available in this particular rate case, the 1.5 seemed to have reasonable amount of support. It doesn't reflect any of the extraordinary uncollectible impacts that resulted from prior years, in some cases distant prior years. It's not based on a number from the 2016, which was used in the last rate case. But this is, I mean, in a normal rate case, you could do what I described earlier, take uncollectibles expense, divide it by utility operating revenue, have 3 or 4 years of numbers. You could argue, do I want a 3-year average? Do I want a 4-year average? But there's normally not this level of debate that relates to the squishiness of the numbers we're dealing with due to the lack of appropriate uniform system of accounts-based accounting information. We just don't have that in this case. So based on everything we've seen as of the time our report was written and sitting here in the hearing room today, the 1.5 looks very supportable by the information in the record. But ultimately, it's going to be up to the Energy Bureau's discretion. I mean, they could go as high as 2.97 if they think that's in some way supported, the 2.86 that LUMA offered in its rebuttal. But to us as experts that deal with this issue of uncollectibles expense in just about every single rate case that we're involved in, and there have literally been hundreds of them, the 1.5 looks to us like a better, more reasonable and correct number to use in this rate case in the context of the information that we're dealing with here.
Just a couple of questions and then I'll wrap it up. Does writing off historical uncollectible debt mean that the historical data was wrong? So that's question one.
No, I mean, typically when the utility bills customers for utility service, they credit revenue and they debit accounts receivable.
Right.
Then as they go forward in time, they're supposed to be analyzing the accounts receivable for whether they're collectible or not. And they should do that under normal accrual accounting in every reporting, every period that's used for accounting reporting. They should calculate a bad debt expense and calculate a reserve for uncollectibles, or allowance for doubtful accounts, it's sometimes called. That's just normal, prudent financial accrual accounting. And any company that has accounts receivable that's following general accepted accounting principles, or that's following the uniform system of account for electric utilities, should be doing that in every accounting period.
To just listen carefully to his question, Mr. Smith. Next question.
And Dr. Tierney said that she's never seen a cash financed utility. Have you ever seen a cash financed utility?
Again,
so I'll give you a definition of that. With a utility without access to debt financing of any kind.
we have not seen a utility that's cash financed to the extent that the Puerto Rico electric utility currently is. Most utilities do have access to some kind of outside financing.
Okay. And I guess my question is, should we use the experience that you have from all the other utilities that have access to debt financing? Should we use that as a proxy here, where we know, in addition to the fact we don't have access to capital, we know that the past accounting work that you described was not done? Does that change your opinion at all about your ultimate conclusion on bad debt?
Hold on. I need a little clarification of that question. Did that question carry the assumption that Mr. Smith and Mr. Dady were using the experience of other utilities as a basis for their recommendation? Was that an assumption underlying the question?
I guess it was, yes, sir.
Well, why don't you ask him if that assumption has a basis to it?
Mr. Smith and Dady, did you use your experience working for other utilities to inform your analysis when you wrote your report and made your recommendations to the PREP?
Not particularly on bad debts, because we didn't have the normal uniform system of account-based accounting information to do the normal typical analysis of bad debts. What we had to use was the responses that we got from LUMA to requirements of information, which is the data from fiscal years 2021 through 2025 that everybody's been looking at here, trying to figure out what to use that to figure out what a reasonable uncollectibles percent is. So we weren't able to apply the normal analysis that we would typically do in other utility rate cases.
Thank you, sir. Appreciate your time.
This,
Okay.
Mr. Hampton, this is Commissioner Ramos.
Sure.
Sorry. Omar, can you pull up the exhibit again? Regarding extraordinary write-offs, I guess this question is directed towards Mr. Andrew Smith. Year 2025, we have 398 million. Would you say that number includes various years of uncollectibles?
Yes, that number actually reflects multi-year write-offs, all predating fiscal year 2021.
Prior to 2021. Is there any way that we could segregate that number per year?
In terms of what years prior to 2021, yes, I would believe we absolutely would be able to, because we identified that on an account by account basis.
So we'll be able to exactly know of that 398, how many millions correspond to each year?
We should be able to identify that.
Would that serve to as data, if you will, to calculate a more accurate representation of what an uncollectible is?
Not necessarily. And maybe let me spend 30 seconds trying to help maybe explain some of this dynamic here. So we have a situation where accounts were not deemed uncollectible for years and years and years. To my point, the $339 million write-off that was recorded in 2025 was for multiple years prior to 2021, fiscal 2021. So when we think about using historical data to try to develop a prospective bad debt expense, to the extent that accounts were not being managed proactively, right, and therefore bad debt estimates were not necessarily being managed proactively, right, that leaves us with a situation where the foundational basis for the denominator in these calculations, as well as the bad debt expense in these calculations, is in question, because as we go through the cleanup, what we don't want to do, let me stop there. It makes it difficult to define a starting point or a basis for this because the accounts have not been cleaned up.
Aside from that number, 2023 and 24, do they include more than one year of uncollectibles?
2024 does as well. It's about $77 million that was also related to accounts outside of the fiscal 21 and forward period.
Okay, thank you.
I have questions as well. This is for the experts. I'm going to ask each one. I'm going to start with Dr. Tierney. Tierney, hi again. In other jurisdictions, similar to Puerto Rico, and you could define similar however you want, number of customers, capacity, complexity. What's the bad debt of other jurisdictions that are similar to Puerto Rico?
I don't have that at the top of my head. I apologize.
Okay. Any other witness that could respond to that question? Ralph and Dady?
Can you repeat the question, please?
Yes. Other jurisdictions with utilities similar to Puerto Rico's utility, and you could use similar however you want. What is the bad debt range that they use?
It's hard to find utilities that are exactly similar to the Puerto Rico electric system because of the unique circumstances. We did look at a bunch of other electric utilities just based on data that we had laying around our office. And Mr. Dady has, him and another analyst in our office worked on that. So I'll let him tell you what the range is.
Okay, this is based on reviewing FERC Form 1 reports for 9 different utilities. Oh, let me rather repeat that then. We looked at data for 9 different utilities based on their FERC Form 1 data for years 2021 through 2024, and then computed an average for each one of those utilities. And the range that we came up with based on those calculations was 0.8% through 1.75%, using the average numbers.
So 1 point what?
I'm sorry, 0.8% through 1.75%.
And I don't mean to interrupt the line of questioning, but do you have the names of those utilities?
Yes.
And are they similar to Puerto Rico? I guess that was the commissioner's question.
Well, whether they're similar or not, that's debatable, but I can give you the names of the utilities. Okay, Mississippi Power Company, Georgia Power Company, Alabama Power Company, Florida Power and Light Company, Arizona Public Service Company, Atlantic City Electric Company, Jersey Central Power and Light Company.
For the interpreters.
Oh, sorry.
And also for me that I'm writing.
Sorry.
Thank you.
Do I need to repeat any of those? Okay, all right. I'll start up. Sorry. Mississippi Power Company, Georgia Power Company, Alabama Power Company, Florida Power and Light Company, Arizona Public Service Company, Atlantic City Electric Company, Jersey Central Power and Light Company, New Jersey Public Service Electric and Gas Company, and Rockland Electric Company.
What was the last one?
Rockland Electric Company.
Rockland? Rockland. I'm sorry, can you also give for each one the bad debt number? Because I know you said it's a range from 0.8 to 1.7.
Sure. And these are the averages we calculate over that 4-year period, 2021 through 2024. So for Mississippi Power Company, it's 0.18%. For Georgia Power Company, it's 0.29%. For Alabama Power Company, it's 0.15%, 1.5. For Florida Power and Light Company, it's 0.8%. Arizona Public Service Company, it's 0.59%. Atlantic City Electric Company, 1.38%. Jersey Central Power and Light Company, 0.25%. New Jersey Public Service Electric and Gas Company, 1.75%. And Rockland Electric Company is 0.34%.
Okay, I only heard one that's 1.38. That's similar to what all the rest seem very low. Is that the case for most utilities in the U.S.?
Based on the cases we've worked on, and there's been many, that generally tends to fall into that range, sometimes a little higher. But I mean, again, this is just based on the companies we, did this, this analysis with.
I want to make sure the record's clear about 2 things. First of all, the numbers that you cited are straight 7th grade math calculations where the numerator is bad debt expense and the denominator is operating revenue, correct?
Correct. The numerator's account 904 on collectibles expense.
Right.
The denominator's the utility electric operating revenue.
And the source is the FERC Form 1s for which years?
21 through 24.
So none of those numbers reflect any judgment on your part. They're taken straight from ordinary calculations from the FERC Form 1s, correct?
Straight from the FERC Form 1
Right.
information, which is the typical analysis that would be done in a rate case.
Are you opining at all as to the comparability between any of those utilities and the Puerto Rico situation, or are you just reporting the numbers?
I would say that some of, like Rockland Electric, particularly in New Jersey, they serve, I think, 2 counties up by New York City. That's a very affluent area, and I don't think they're in any way compared to Puerto Rico, other than their electric utility. That's some of the other ones, Mississippi Power, Alabama Power, Georgia Power, you know, they serve large areas of the state, of those states, some of which are rural, some of which are economically challenged. Those might be comparable, but probably not to Puerto Rico. The Public Service Electric and Gas in New Jersey, they were the ones, I think, with the highest uncollectible rate. That could be the one that's actually most comparable to New Jersey in terms of some of their collection issues.
The translators hear us now? The translators cannot hear us? Yes, they can? Okay. Commissioner,
Okay.
can we get everybody's attention, please? Commissioner Torres, would you continue, please?
Ralph, you mentioned that several years, we need data of several years of the uniform system of account. What is several years? How can you define several years?
In a typical utility rate case, I think they would be looking at 3 to 5 years of historical information. And then I know in this case, it goes back into 2021, which was, if you're talking about uncollectibles, people would usually start asking, wasn't that affected by the COVID pandemic? And, you know, should you really use that year or exclude that from some type of average?
His question for Luma, is Luma in the uniform system of accounts? Because I understood that you weren't.
We are not.
Okay.
And that's a subject we'll be exploring in the record-keeping panel.
Okay. My question is, I think we wouldn't have to wait for Luma to be in that system to actually ask for a real bad debt number based on data. That was a comment.
I don't believe that's true in the
No.
case of bad debt.
No.
And what's the reason for that? Is the reason that you can just look at, I mean, if at the end of fiscal 26, you'll have bad debt expense information and you'll have operating revenue information, correct?
That's correct.
And that would be 1 year, wouldn't be Ralph Smith's 4 years, but it would be a start toward the process.
That's correct.
This goes back to our earlier discussion that there's truly a balance sheet, the difference between the balance sheet and the income statement.
Yes.
Does anyone know, this is to anyone on the panel, what does the PREPA certified latest fiscal year have as bad debt? If it has a number?
Sorry, are you referring to the fiscal plan? Or the, the
fiscal plan, the
fiscal
certified
plan.
fiscal plan approved, certified by FOMB.
My understanding is they apply a 1.5%, which has been their practice for the past couple of years.
Doesn't that fiscal plan bind us to how we structure PREPA?
I would not be able to comment on whether it's binding or not. What I could say is the FOMB's approach in the past couple of years has been to defer to the budgets approved by the Energy Bureau. So if they stick to that methodology, then whatever the Energy Bureau determines as part of this rate case would be certainly considered by the FOMB as what would go into subsequent budgets or fiscal plans.
LUMA has been using the 1.5 based on our budget approval for the last 3 years. Is that correct?
Yes, we have not until now proposed any different amount.
Can LUMA live with the rate period the next 2 years with the 1.5?
I defer to my colleague on the impacts of that.
There's a two-part answer to that question. One is that to the extent that the bad debt ratio understates bad debt, the actual bad debt experience, there will be under collection because of that. One of the things, I wasn't on the panel, I don't know if it's happened yet, there is a conversation around decoupling as part of this rate proceeding. To the extent that there's decoupling, and the collection experience of the utility is reflected in the adjustment, the bad debt, by definition, is an estimate and becomes less critical if there's a true up of that over time.
That depends on the type of decoupling, correct?
Absolutely.
If it's only revenue decoupling, is your answer different?
Yes.
Because revenue decoupling would not account for differences between actual and expected in terms of expense.
That's correct.
Would it also be different if we approve the reserve accounts that LUMA is requesting?
The reserve accounts would have no bearing, or vice versa. The bad debt expense would have no bearing on the reserve accounts. It's simply how much of a given dollar does the utility actually collect.
Okay. No more questions. Thank you.
Let's see where we stand so we make a good decision about lunch break and not stress people. Mr. Stolberg, what is it that you had next? I'm sorry, but before we get to Ms. De La Rosa.
I just wanted to follow up with Mr. Smith and Dady on the sample.
Okay, so you've not completed your cross of Mr. Smith and Dady, is what you're saying?
Yes, I have 4 or 5 questions on the sample.
All right, let's do this, folks. Let's complete the cross of Smith and Dady. And then I really don't think this is a good time to start a half hour of cross by Ms. De La Rosa. We're getting close to 1 o'clock. So let's finish with Smith and Dady and see where we stand. Mr. Stolberg, please.
Thank you, Mr. Hempling. Gentlemen, this is a question for whoever would like to answer the question. The sample we discussed earlier with was it 8 or 9 utilities?
It was 9.
9 utilities. You are not representing that those are represented, that is a representative sample either of all mainland utilities or of utilities similar in any way to Puerto Rico, right?
Right.
And in fact, do you know if any of those utilities have an AMI system of the meters?
Probably most of them, wouldn't you say?
Would you assume that they do?
I don't think all of them are fully 100% AMI, but I think most of them do. I know that Georgia Power has an extensive AMI. Some of the New Jersey utilities, I think they're still in the process of rolling it out.
Okay, and if they do have an AMI system, that allows them to remotely disconnect non-paying customers, is that right?
Yes.
And so you would expect to see with an AMI system, you'd expect a lower uncollectible amount in general.
Generally, yeah.
Okay. And have you done any analysis about the per kilowatt hour average price for any of these utilities as compared to the per kilowatt average price charged in Puerto Rico?
Not specifically, but it's our general understanding that the per kWh price is in Puerto Rico is quite a bit higher than for most of the mainland utilities. I think there's some electric utilities in Hawaii that have similar per kWh prices, but in terms of the continental U.S., it's our general understanding that virtually all the electric utilities have prices that are lower than in Puerto Rico.
And so just as a matter of logic, because our power is more expensive here, you would expect to see a higher bad debt percentage because it is harder for people to pay given the same relative income.
I think that's a reasonable conclusion, yes.
Did you do any analysis about the residential, industrial, commercial mix with respect to these 9 utilities versus the residential, industrial, or commercial mix of customers in Puerto Rico?
No.
Okay, nothing further. Thank you very much.
Yeah, I just want to be clear. You brought that information in case you were asked about it. It's not part of your proposal for. It's not. Let me just ask this less affirmatively. Why did you have those numbers available today?
Well, we were thinking about questions we might be asked at the hearing, and I thought somebody might ask, what is a reasonable uncollectible rate that's being used by other United States electric utilities? So we quickly looked at what information we had readily available in our office for some utilities that we thought would be generally comparable to the Puerto Rico electric system. And another analyst in our office, and Mr. Dady, compiled this. It was done basically, I think, in about a day. So it wasn't meant to be any kind of comprehensive analysis by any means, but we thought we needed to look at something and we had information readily available. So we pulled this together basically to be able to answer the question that, in fact, was asked of us today.
Okay, thank you. Mr. Gonzalez, did you have a few questions? Okay, I want to know, do they relate to bad debt, or are these the general questions that have connection to all revenue requirement? Is that basically it? Okay, and what would your estimate your time be? Okay, sir, why don't we go ahead and then what we'll do, so I don't have to make another announcement, is we'll take our break. We'll come back with Ms. De La Rosa's questions, and then I think we would have completed the questions on bad debt. Am I right? No other questioners, so then we'll go to a redirect. I know I sound like a broken record, but right now I'm not sure how we're going to solve this evidentiary problem other than possibly through people stipulating jointly that we'll use number X and nobody will go to the Court of Appeals about it because. But anyway, let's see what Mr. Gonzalez has and we'll take a break. Welcome, sir.
Thank you very much for the opportunity. I have a couple of questions for either Mr. Figueroa or Mr. Andrew Smith. One of these questions I will also ask from Mr. Ralph Smith. Okay. Mr. Figueroa, will you agree that you are one of a handful of people in this room today that were in this room in 2016, 2017 for the previous rate case?
I was.
Mr. Figueroa or Mr. Andrew Smith, did you load Exhibit 491, the feature and how with revenue requirement revised November 2016 of KC EPR AP 2015-001 to the record?
Are you asking if we?
Yeah, the exhibit says that it was loaded by you.
What's the exhibit number?
Exhibit 491.
491?
Okay.
What is the question, sir?
If they were the ones who put it in the record.
Okay.
Council would have put it in the record, but.
All right. The council says council put it in the record. Next question, please.
the next question is, do you agree with the recommendation in page 62 that only the projected billed kilowatt hour sales for fiscal year 2017 be used?
Used for what, sir?
For the previous rate case.
What document are we looking at, Mr. Gonzalez?
We're looking at a document prepared by Fisher and Horowitz regarding the revenue requirement.
In 2016?
On that case, but the pertinent part of that report is whether the 2017 projections for fiscal year 2026, 2027, and 2028 should be used.
And these are projections that were made a decade ago?
And these are projections that you are using now.
Okay. I still don't understand the question. Is the question, are you asking Luma whether it's proposing to? Here's the problem, Mr. Gonzalez, the protection. I'm not getting the question, sir, and I may be the only one in the room.
Let me go through it.
No, I don't want you to go through it. I want you to. Yeah.
Señor Figueroa, permiso, licenciado Figueroa, en ese reporte de Fisher and Horowitz, ¿no? Dice en la página 51 que los statements de prepa acerca de forecasting no son predictive. ¿Ok? ¿Usted está de acuerdo con ese statement? ¿Eso está ahí o no?
El subinciso número 2 de la página 51 del informe dice eso, sí.
Ok. Y en el inciso 62,
I don't think the translator got the witness's answer. At least I didn't hear it.
Could you answer again, please, Mr. Figueroa? I don't think that was translated.
El inciso.
La página 5.
Answer the question again.
El inciso número 2 en la página 51 del reporte indica lo que el señor González dijo.
Y en la página...
Go ahead, please. Just a second. A reminder, when we're doing the translation, have everybody's attention. You must wait by looking at me for the signal. That's the only way for us to do this. Everybody ready? Mr. Gonzalez, are you ready for the next question?
I am, and I'm going to ask it
Second.
in English as slowly
Go.
and as well pronounced as I can. Okay.
No, just speak in Spanish. Go ahead.
I would prefer because I had them in English. Do you agree, Mr. Figueroa, with the recommendation in page 62 that only the projected billed kilowatt hours sales for fiscal year 2017 be used and not any other?
Be used for what?
For projections of what the billed kilowatt hours will be in the future.
Mean for fiscal year 26 and 27?
That's right.
All right, just answer the question, sir.
Is this about load forecasting?
I have no idea what it's about, but I think if we just answer the questions and not worry too much about it, we can go to lunch.
So we prepared our own load forecast based on the most recently available information for purposes of this rate case. We did not use the 2017 or the load forecast you developed by PREPA for the 2017 rate case.
Next question.
I guess that is contrary to what the report, which we will see in the rate case of Estrada says. She says that you use the projected 2026, 2027, and 2028 when you were doing the forecast.
I thought you were asking about the projections 2017. I thought
That's
you were
right.
about the statement.
Don't interrupt. Don't interrupt him, please.
I'm sorry. If you're asking if we projected sales for 26, 27, 28, is that the question?
What I'm saying is,
Don't say, ask a question.
what did you use to project those sales?
It's the projected sales for 26, 28, 27, and 28.
Yes.
The historical information that we collect, plus judgments about future behaviors. Yes, which is I mean I'd understand if you could explain the link that you're trying to establish between the 2017 report and
the link is.
No, don't ask him to explain the link. Just ask the next question.
So why is Luma using PREPA's 2017 forecasted kilowatt-hour sales for fiscal year 2026, 2027, and fiscal year 2028 in the current rate case?
Are you?
Okay, Ms. Estrada could confirm, but I'm not aware that we are using the 2017 forecast for 27, 26, 27, and 28.
Next question.
So if you will have used that, you will agree that that is incorrect to use it.
We did not use it, so I cannot agree or disagree.
But in the hypothetical that you did use it, you will agree with me that it was incorrect to use it.
Hypothetically, if you were to use it, would that be a problem or not a problem?
Well, and if the question is whether the forecasts for those 3 years, 26, 27, and 28, develop in connection to the 2016-17 rate case, if that forecast is relevant today, then I would say no, because we have more recent information that allows us to better estimate 26, 27, and 28.
Mr. Figueroa, that's not the question. It was a straight question. You danced around it. My question was, if you did use the numbers from the 2017 rate case to project the kilowatt hour.
I'm sorry, I'm sorry. I'm just going to overrule the question because the hypothetical is too far-ranging from reality to make the evidentiary, to make the result evidentially useful. Next question, please.
I don't have any more questions for him. I have a question for Mr. Ralph Smith. If that's okay.
What is the subject?
It's a similar subject.
Did you do anything to do with load forecasting, Mr. Ralph Smith?
Can I ask my question?
No, you can't. I want to see if he's done anything
If
relevant.
I cannot ask my question, then I will ask permission to remove myself from this room because I'm here just for one purpose, which is to defend renewable energy. And I think you are curtailing my right to try to get to the bottom of renewable energy. And I just have 7 questions that take 2 minutes, and I ask the indulgence of this proceeding to allow me to do that.
Thank you, Mr. Gonzalez. Before you do that, I need to make sure there's a foundation. Have a seat, please.
I could establish the foundation with my first question.
Mr. Ralph Smith, did you have anything to do with load forecasting in this case?
No.
Next question.
In page 47 and page 53 of your report, do you say the following statement? Further, other factors can affect whether an approved base rate revenue requirement is actually collected. Factors causing variability between approved and billed revenue requirements include, number 1, variations between billed kilowatt sales and forecasted kilowatt hours.
Yes, I think we at least had that on page 27.
47 and 53. You repeated that in your conclusions.
Yes, I believe we did say that.
Does that establish a basis for my questions?
I don't know. Let's hear what the question is.
Okay. You also filed testimony and participated in the previous rate case.
Yes.
The base rate is determined by the revenue requirements divided by the projected billed kilowatt hour sales. Yes or no?
Based on recollection, I think that the rates were based on
No, as a general,
the
as a general, as a,
5
gen-
kWh sales.
as a general base rate, as a general thing, is determined by the revenue requirement divided by the projected billed kilowatt sales, right?
There's typically a portion of the rates that's a monthly fixed charge, and the remainder is per kWh.
So the answer is yes with respect to the portion of the rate that's a kWh charge.
Correct.
Next question, please.
If those projected billed kilowatt hour sales number turn out to be higher than what is projected, will that result in a lower base rate? Yes or no?
The denominator's higher and the numerator's the same. That would tend to result in a lower rate.
Okay.
And if the denominator is lower and the numerator is the same, everything else being equal, there's a higher rate.
Correct.
Next question, please.
Were you provided projected billed kilowatt hour sales data for your analysis?
Our analysis, we weren't looking at that stuff in any degree of detail.
Mr. Smith and Dady did not propose a rate in this case. Did you, gentlemen?
No.
So you did not make any analysis because you did not get any kilowatt hour sales numbers, right?
They didn't propose a revenue requirement or a rate.
That's not the question. My question is if they looked at the projected kilowatt hour sales, because they mentioned that in page 47 and 53. That's all. Did they look at something?
He gave you the answer. He gave you the answer. The answer was no. Next question.
Did you look at the projected billed kilowatt hour sales for fiscal year 26, fiscal year 27, and fiscal year 2028 that the FOMB approved fiscal plans of 2017, 2023, and 2025 projected?
I don't recall that we looked at that in any degree of detail. We may have looked at it, but we didn't analyze it.
But you did look at the fiscal plans?
We looked at the physical plan at some high level.
Just as I asked him, did you by any chance analyze the Fisher and Horowitz 2016 report from the previous rate case that was introduced to this rate case as Exhibit 491?
We looked at that report, which I think was also referenced in our report in the 2016-2017 rate case.
Okay. Will you agree with Fisher and Horowitz determination that PREPA's forecast is in general not predictive? Page 62 of the report.
Did you look at any forecast for this case?
Looked at a forecast at a very high level. We didn't attempt to analyze it.
Okay, but you mentioned that you had even included the Fisher and Horowitz report in your presentation. So my question is a straightforward question is, do you agree with their determination in page 62 that PREPA's forecast were not predictive?
Sure, how to respond to that.
Okay,
that was
all right.
the conclusion. We didn't attempt to verify it.
And also the recommendation that only the projected billed kilowatt hour sales for year 2017 be used, and that the all projected forecast billed kilowatt hour sales, such as the one for the fiscal year 2026, fiscal year 2027, and fiscal year 2028 not be used.
I don't recall that
Okay,
specific
perfect.
part of the
Okay.
recommendation, to be honest.
I just have two more questions. In your professional opinion, you mentioned that you have seen the Form B PREPA fiscal plan. Should the projected kilowatt hour sales of the Form B PREPA fiscal plan should be the ones used as the projected kilowatt hour sale number?
We're not expressing an opinion on the KWH forecast in this rate case.
If not that projected kilowatt hour sales number of the Form B PREPA fiscal plan for fiscal year 2026, fiscal year 2027, and fiscal year 2028, what, in your professional opinion, should be used in this rate case for the projected kilowatt hour sales number?
We weren't analyzing that and do not have a professional opinion about the KWH sales forecast that should be used in this rate case.
You don't have.
He answered the question, sir.
Thank you very much. That's all.
Mr. Hempling, before you, it's really short. Just I just want to know if Luma's council can say or state the purpose of that, entering that exhibit into the record 491.
Margarita Mercado for the record. I would need to corroborate, but I think it was quoted in a testimony. It was background material. Yeah, but I'll need to check.
Okay, thank you. That's it.
Mr. Gonzalez, my question, Mr. Gonzalez, can I ask you, it's just that you were in exhibit 491 and you were mentioning on page 62, it said that they had forecast for 226 to 28. Where exactly is that? Because I can't find that.
From what I understand of that report, Fisher and
Horowitz.
Fisher and Harwood conclusion was that forecast other than the 2017, the one projected for 2017, for other than that, all the other ones should not be taken into consideration. And that meant the projected forecast for 2026, 2027, and 2028. And my contention is that Ms. Estrada, on her report, are using those. And that's all that I want to establish here, because they're not going to be on the rate design pack.
Could I clarify for a second? Because
No, just 1 second. What is your follow-up, sir?
My follow-up is that I want to know exactly where it says it in this report because I can't find it.
that's what I can clarify. If you give me
Go.
30 seconds.
Page 62.
No, Mr. Figueroa, speak.
The report from Fisher Horowitz criticizes PREPA's load forecasting methodologies.
10 years ago.
10 years ago. Resulting from that, there's a load improvement program that the PREP has required to implement. We, Luma, have been implementing that for the past couple of years. So our forecasting methodology is better than what it was for PREPA in 2017. And just to be very clear, the forecast used for this rate case is entirely developed by Luma and not based on any forecasting performed by PREPA in previous years.
I'll see.
I will save my questions regarding that for the rate design case, because Mrs. Estrada is going to be here, and I'm going to confront her with the statements made by Mr. Figueroa.
Okay.
If that is acceptable.
All right, when you do that, you're going to do that as efficiently as everybody else does. And I'll hold everybody to the same standard of efficiency. Because when we get to that point, we'll be in our last week. And we want that last week to end that week. I would like to see, thank you for productive morning. I'll see everybody back at 2:20. Thank you.